Sitting 10:45, sir. Online advocates, sitting 10:45, sir.
Okay, understood, madam. Thank you.
TCR ಬಂದಿದೆ ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಹಾ
Sorry, we got late today. Yes. Use the mic.
MFA arising out of an arbitral award. The award was passed in year 2006 and further confirmed in 2016. The appellant has filed this after lapse of 8 years, my lords. I filed my objections to the IA for condemnation, my lord. It may be taken up on the IA, my lords.
No, what is that IA for?
My lord, they filed an IA for
What is the date of hearing?
no date.
Any date?
No, my lords, date has not been fixed.
Who is the other side?
My lord, I've informed them, my lords, there.
You file an early hearing. Have you filed any application?
I filed objections to the IA.
You file an early hearing.
Much okay.
Okay. Yes.
This matter, I am for impleading applicants, your lordship. Notification has been quashed, your lordship. So I am for the impleading respondents, your lordship. Any date may be fixed.
What is the urgency?
Lordship.
You are impleading, you are part of the appeal?
No, your lordship, I am part of respondent, your lordship.
That's right. You are in the appeal now as an impleaded party.
No, your lordship, I have filed this impleading application, your
You
lordship.
have filed an impleading
Yes, your
application. You have given it to the other side.
Yes, your lordship.
You have given it. What is the date of hearing?
The date of hearing is not fixed, your lordship.
It's not fixed.
Not fixed. Your lordship.
You will inform all the sides,
Yes.
the appellant, the respondents, everything, then have you filed an application?
The impleading application have been filed, your lordship.
You have filed it?
Yes, your lordship.
No objections?
No objection has been.
Just take that. Give it after 2 weeks. But you will inform all the parties?
Your lordship, I'll inform BD and also.
Yes.
Commercial appeal.
Not only appellant, even the respondents.
Yes, your lordship.
Commercial appeal. For this one, we have filed the interest portion, your lordship. They have denied the interest portion.
Is it a pending matter?
Pending matter, your lordship.
File an early hearing. File. Yes, ma'am.
It's commercial appeal of 2022. I moved this matter earlier and 4th March date was given. However, the matter was not listed on 4th of March, my lords.
Why?
Because there was some issue, delay with the scanning of the IA that we had filed. my lord.
What is this? Check up this.
I've taken endorsement of the other side on this.
You
as
should have mentioned it on that day when it was not listed.
The file hadn't gone for scanning, my lord. So anyway, it could not have been listed at that.
No, but you should have mentioned it. Yes, ma'am.
My lord, I have a decree of eviction against my tenant, my lord, against which the present arguments. This honorable court has granted a stay subject to deposit of 75%, my lord. They have deposited 75%, but the decreed amount included rents only till the date of filing the suit, my lord. From September 2020.
What are you mentioning?
I have an IA for early hearing, my lord. They're not paying me current rents.
You have informed the other side,
I have intimated them by a mail. I filed an IA.
but you'll inform the date also. They are, you are the respondent.
Yes, my lord, please.
You'll inform the other side. Just
The
take that.
date given was June, my lord, if it can be taken up, because another 3 months they will
Oh,
not.
there is already a date.
June, in the month of.
Ajay, but this is early hearing.
Please.
We'll list the early hearing. We will see it. Use the mic. Use the mic. Mic.
I'm for the respondent in this matter, my lord. The petitioner has a stay on this matter, my lord, on my
What
term.
is it in writ
Writ
appeal?
appeal, my lord. Petitioner has a stay in this, my term is going to end on March, my lord.
Term what? Appointment or what?
Appointment, my lord.
Okay.
I was already been appointed. My appointment has been stayed by this court, my lord. My appointment was only stayed, my lord. There is no direction on the forming of a new committee, my lord. But the petitioner has now formed a new committee, my lord. So kindly the matter may be taken.
Now, what
tomorrow.
is the urgency?
Because there is a festival, my lord, on the 13th of this month.
For what?
A temple festival, my lord.
So,
There is because my term is going to end this March only, my lord. They have formed a new committee. The new committee
is it a pending matter?
Yes, my lord.
What have you filed? Is there any application you have filed?
No, my lord. I have filed an objection on the matter, my lord.
So then why don't you move an early hearing? Have you informed the other side?
I will inform.
No, you file an early hearing and inform the other side and mention it tomorrow after filing early hearing.
My lords, this is a service matter, my lords. The matter was dismissed for default, my lords. So we have filed an IA for recalling the orders and allow us to
Just
submit on merits, my lords.
The
Thank you.
other side was appearing,
Yes, my lords, we will send the.
just inform them.
Yes, my lords. My
You are
lords.
for the appellant,
Yes, my lord.
petitioner.
Yes, my lords. We are for the petitioners.
Just check up that. Is it our roster? Ma'am?
For 11th, my lords.
Don't come. No. This is not roster, this roster. Yes,
My lord, RFA, my lord, this RFA was dismissed.
not RFA here.
Because I had given it that day and my lords had asked me to take the endorsement of the other side. I had given it and the pending had given the date of 4th of March. Regardless, there's an attachment that a property of the appellant has already been attached in the trial court
Then what is the?
and the execution matter has been stayed, my lords. I've given it here. My lords had asked me to take the endorsement.
You should not do that.
No, no.
You will
After
mention
endorsement,
it
I
here.
gave it here, my lords. I'm not sure why it's not recorded.
Did we give a date to you?
Please, 4th of March.
Just check up that one.
I am-
Yes,
I am for respondent, my lord. I seeking the vacating the interim order
what have you filed?
for hearing on high.
You filed an IA.
Yes, my lord.
Have you served the other side?
Yes, my lord.
You
We
have
have
served
informed. Yes, my lord. We have already served.
the application.
Yes, ma'am.
You'll inform the date also.
Okay, ma'am.
Just take it, ma'am.
Please, ma'am.
Any objections on the application?
No, ma'am.
Just check up.
My lords, this is a commercial appeal. The arbitral award was upheld. It was in 2023, my lords. The appellants preferred the present appeal in 2023, after which they have not, and the matter is listed, I think, my lords, in January. We were unable to appear at that point of time due to a personal emergency. We seeking. to
What
post the
happened?
matter.
What is the next date?
The next date, my lords, is April 16th, my lords.
So what do you want?
My lords, we seek an early posting, my lords.
No, you will file an early hearing.
Yes, my lords. We had filed it.
You file early hearing.
Yes.
Login login.
Yes, my lords. We filed
When
it.
did you file it?
On 7th, my lords.
7th you
7th
have
of
filed
March,
it.
yes.
So we'll list this application.
Sure.
But you have informed the other side?
Yes, my lords. We filed the application. We have informed them, my lords. I will inform them of the
Inform
date.
the date also.
Yes, my lords.
Just take it.
My lord, I am for appellant, my lord. We seeking for this, vacate this stay. For, I am also filed the IA.
You have filed an IA.
Yes, my lord.
What is this? Just check up.
IA for stay.
Stay application for.
Yes.
Stay application for.
Yes, ma'am.
Wait a minute.
2024, they filed application for stay.
Your vacation or stay? Be there for appeal, not stay as well. Is the respondent appealing, just asking. With a fresh matter.
Fresh matter,
Old.
respondent advocate idara,
No, ma'am.
advocate represent agilla.
Is it a fresh matter or?
Old matter, my lord.
Then, have you filed a stay application
Yes, my lord.
along with that? Along
No.
with the appeal?
Yes, my lord.
You file an early hearing.
Please.
Is the other side appearing in this?
No, my lord. No, my lord.
File an early hearing. You have given that. You will inform the date also,
Yes, my
the
lords.
other side,
Yes, ma'am.
all the matters.
For adjournments. Page number 6, 18 to 20. Page 7, 21 to 25.
It's serial number 23, my lords, 23. I've informed the other side, they're also here. Just request for 2-3 weeks' time, my lords. If I'll have synopsis in the meantime.
Who
the
is the
respondent.
appearing?
For the respondent.
So what do you want, ma'am?
My lords, just 2-3 weeks' time, my lords. We'll file a synopsis in the meantime.
Let the written submissions be filed
Yes, my lords.
before the next date of hearing. You have filed it? No.
No,
We'll
my
also
lords, we
file.
both have not filed.
Okay. They just say counsel for the parties to file written submissions 1 week before the next date of hearing.
23-6.
Much obliged.
Obliged.
Page number 8, 26 to 28. Page
Serial number 28, my lord, applying for the applicants. My lords, we need 1 week of time to file an additional documents.
Which is the number you're mentioning?
28, serial number 28.
Yes, what do you want?
My lord, we have filed an IA2 for the stay, and they have to file an objections. And we have to file some few additional documents, so we need adjournment for 1 week.
Who is the other side? Have you informed?
No, my lord.
Just wait then. Just wait. Next.
Page 9, page number 10. Serial number 1, Shri Kumar MN.
Serial number 1 and 30 are same. Kindly may be taken up along with 30 serial number 30. Make submissions, my lords. this file was misplaced in the registry, we could not. We have taken along with 30.
4 weeks are granted to remove the office objection.
Lordship may make submission. Serial number 30 is one and the same arising under the
Yeah,
same.
this is the same. Why? What is the difference?
There is 18th, there is a contempt petition. That's why it was moved and taken.
You are ready? We
Yeah.
can hear it.
Yes,
But tell us one thing. Now,
1 and 30 both are same.
yes, 1 minute, Mr.
Yes,
Kumar.
yes, yes.
Now, just file, give the file. Now, tell us one thing. What happened to that judgment?
Which judgment?
The earlier judgment, which has been quashed, the notification.
But that judgment is still pending before the Honorable Court. They have challenged in writ petition. There are 6 such writ petitions. 2 are belong to Bangalore division.
What
2 are.
happened? Is there any stay in that?
There's some issue with regard to initially it was dismissed and then recalled. Then it is still in the not yet been taken before the court.
Unless and until you get it, that listed decider, this should follow.
That has to go before the very same bench. That's what is been ordered. Somebody else will appear.
It may be, you can get it done, but unless and until
But
that
it's,
issue is decided, we can't do anything. in
No,
this.
what I request, this very judgment of the tribunal earlier round, the same issues decided division bench that I have placed it on record. Maybe taken along with 30 minutes, make submission, but there's a contempt on that.
Then we'll give, what is, no, but tell us one thing,
Serial number 30.
like this, Mr. Kumar.
Yes, I understand, the issue is that there are division bench judgment of this Honorable Court says that it is in law, it is correct. But the tribunal says that without looking at the judgment passed with this Honorable Court.
But the tribunal only followed that notification which was quashed. The effect of quashing of the notification is what the tribunal has done.
Without referring to the judgment matters. This judgment has not.
It doesn't really make any difference.
It makes difference because that has been held to be valid.
Now, what do you want now?
Request a stay as far as serial number 30 is concerned.
See, in this eventuality, in these facts, unless and until you get that thing called or set aside, the consequence is what the tribunal has held.
Since that is also pending here, some difficulty in that matter, what has been faced by the other council and now it will be little difficulty, because of that, I am making prayer.
And when was that petition filed?
Filed 2-3 months back, prior only, not now. 2-3 months prior only. Yes, this is only a frequent situation where we had. That's all. That as far as first matter is concerned, the registry could not.
1 minute. 4 weeks are granted to remove the office objections. Mr. Kumar presses for the stay of the, where is your stay application?
In the writ petition itself, prayer.
Would state that the contempt petition has been filed and the date of hearing is
On 18-3 months.
even in the item
Both
30.
30 also, same.
There is a contempt there
Yes,
also.
In both matters is there. It is going to
If
appear
that
on
be-
the.
If that be so, on a mentioning made before the tribunal for an adjournment beyond the date fixed by this court in this petition, the tribunal shall adjourn the matter. You will make a request.
Yes.
But we are not issuing notice. We want to be very clear.
In both matters, one and.
Yes, both the matters.
24/4,
Which is the date now?
24/4.
Okay. Both the matters. There is a contempt there also. Are the objections there in item 30?
No objections in that matter. In this first matters, registry could not secure the file. It was misplaced for some time. Then now, when the memo went immediately, they have sent it to the board branch. That's all.
Just show 30, item 30.
Serial number 2,
Let's for the plans. But for filing, but complying with the office objections, it requires some time.
Office objections be clear within 4 weeks. Just give it in June.
Much obliged.
10/6, serial number 3,
My lords, for the petitioner, my lord, seek a week's time to comply office objection.
Office objections be clear within 4 weeks.
11/6,
Much obliged.
Serial number 4, Shri Kanishk Ravindran.
This matter, I beg to appear for the petitioners, my lords. Lords, in fact, my lords, this matter is coming up for the 4th time, my lord. The status report has not been filed till date, my lords.
I'll file, my lord, short accommodation.
You
2
should
days.
have filed it.
I'll file it, my lord. Dear. My lord, earlier 2 crimes registered, my lord, with respect to the same missing person, my lord. We have traced, my lord, in the year 2017. Similar complaint was registered.
You show the file.
First crime, my lord, 54 of 2017 was registered in KGF, my lord, wherein she was traced in 2022 and it was closed, my lord.
But you
And
should tell us now what the nature of investigation you have carried out.
I'll place, my lord. My lord, a lookout notice has been issued, my lord, to all the police stations, where in the earlier missing complaint, my lord, she clearly states she does not want to stay with the petitioner. And she was traced somewhere in Ooty with respect to the other missing complaints. And she was brought to KF. Her statement is recorded where she denies to join the petitioner. It's a matrimonial dispute, my lord. The remedy lies somewhere else. He has to approach the family court. Unnecessarily, the police have been dragged in this matter. Earlier
2
also,
weeks,
this
2
honorable
2 weeks for status report.
26-3,
please, my lord.
Please, great.
serial number 5, Government Advocate.
Insofar as non-filing of paper book is concerned, my lord, we have already
the
filed it
respondent.
on 5th of January. And insofar as written synopsis are concerned, my lord, it's ready. We'll file it in the counter today. We'll serve, my lord. So far as the deposit is concerned, my lord, it's taking some time because there's a change in secretary and ultimately cabinet approval is required because of the amount that is involved, my lord.
How
I'll be
much-
filing an appropriate application after seeking instructions from the secretary, my lord. Anyway, the execution is coming tomorrow, my lord. Your lordship had granted conditional stay. Once I receive, I'll make an appropriate application in that regard. And
My lord, it's already delayed by 9 weeks. My lords had passed an order stating that 175 crores has to be deposited. Before the execution court, my lords, none of the government pleaders appear. Despite the delay, my lords, and my lords had passed in the previous order that if they don't deposit, the execution court can proceed with the execution proceedings. Now, my lords, belatedly after my lords 3 weeks, a further request is made. No application is filed seeking extension as well.
We say nothing on this.
Please, ma'am.
What is there to be said?
Please.
We say nothing. Just say that Leonard counsel for the appellant states that the paper books have been filed
on 5th of January, my lord.
on 5th of January 2020.
Written synopsis is ready to be filed.
The
today.
submissions and the written submissions shall be filed during the course of the day. That is request re-notify.
Thirteen six.
May I request for a shorter date if possible, ma'am.
Not possible.
Matter has been pending for quite some time.
You're right. Difficult.
Please, I'm grateful.
Okay.
Grateful.
Serial number 6, Srimati Lata.
I'm appealing for respondent number 2 as a party in person, madam. I have received the notice and I would be filing objection to the IA that they have filed, madam. And also to the main petition.
Yes, there is a notice to go. Who appears for respondent number 2?
I am appearing, madam. Respondent number.
appearing?
Yes, yes, madam.
Just say that though respondent number 2 is still unserved.
It is served today.
Students appearing states that advocate, what is a good name?
Umapati, madam.
Mr. Umapati. Acha. Umapati, who appears in person.
Yes, madam. Yes, madam.
Who appears in person. What do you want?
Madam, I will be filing a statement of objection to the IA and also main application.
He intends to file objections to the IA. Okay, the same be filed within 4 weeks, rejoinder within 2 weeks thereafter, list on.
17-6.
Deeply.
My lord, in the meanwhile, my lord, stay of the impugned order, my lord, since there is a trespass imposed in.
Have you filed any contempt?
No, there is no contempt, madam.
It's all right.
As per the impugned order, my lord, the administrator, page 68.
The issue involved is whether
Whether
the
the
appellant falls within the definition of a public authority under RTI Act.
A
That's all the
similar matter stay has been granted by this honorable court, my lord, in writ appeal number.
Bangalore tough club case is entirely different because the ownership question is there before the Honorable Supreme Court.
We will
Here-
look into that. But
Yes,
tell
madam.
us one thing. Let's see the impugned order.
The Lord would find at page number 22.
So now there is a declaration only.
Yes, sir.
There is a declaration only.
Please, my lord, and impugned order of the page 69, my lord, there is a trust imposed to appoint a public information officer for the appellant.
Who has said so? Who has said?
The commission has
Sir,
declared.
R1, my lord, respondent number 1
Hmm.
has ordered to appoint an administrative
69. What is the date of the order?
date of the
Now,
order is.
are you seeking the implementation of this order, Mr. Umapati?
No, we only want that authority to be under the public authority.
That's right. But
That's-
that issue need to be looked into by this court.
My lord, the single judge has ruled that it falls under the public authority after considering the detailed judgment of the Honorable Supreme Court. And the similar matters also pending before the other division bench, such as the Mysore Race Club and also Bangalore Club and other.
We are only seeking, are you seeking the implementation of this order for appointment of an information officer, appellate information officer under the RTI Act?
As of now, madam, if your lordship decided about the nature of the public authority or not.
That's right. We are
Yes.
simply asking, are you seeking implementation or not?
If it is implemented, really it comes under the public authority, madam, because unless a public authority, there should be a public information officer to give information to the public, madam.
Today, have they appointed?
No, till date they have not appointed.
Are you seeking implementation?
No, madam, I am not seeking.
That's all we want.
If if the same undertaking is given, my lord.
So surely till next date, you will not see.
No, madam. For the last 10 years, we have not implemented, we have not pressed upon this.
Right. So shall we record it or
Please, madam.
this assurance is enough?
Yes, ma'am. Assurance is enough, madam.
Sure.
Sure, ma'am, sure.
Next.
Acha, ma'am.
And Shri Karunakar.
Appellant, his objections are complied. For appellant, my lord, in this case.
Yes.
His objection, all that his objections are complied.
So there's still one office objection there.
We'll do needful, my lord.
Within just office objection be cleared within 4 weeks,
1 week, my lord, I'll,
within 1 week.
please. A date may be given after 1 week.
Just give it date.
24-4.
Next.
Serial number 8. Siddharth.
Appearing for appellant, my lord. My lord, notice should be reissued to R2 and R3, my lord. Any date might be given after 2 weeks.
What is this?
My lord.
Yeah, notice we issue to respondent 2 and 3, returnable on.
17-6.
My lord, any date in the first week of April. First week of April, ma'am.
It's all right. Next.
9. Shimali Patil. Serial number 9.
Appear for respondent 2 to 24. Office submissions have to be
State
completed.
appeal, my lord, is also filed by the state government. Just to be heard, my lord, because the delay was caused due to the, my lord, review was filed. My lord, after the dismissal of the review petition, my lord, the appeal was filed by the state government as well as by the what has happened is contesting.
The posts are already reserved, my lord. They are all vacant. From 10 years, the petitioners are running pillar to post, my lord. They're all COVID warriors.
Not whether they are
And
entitled
the
for
assurance was
regularization.
given that they will be regularized. Only on that ground, the posts were reserved. 1 or 2 posts are reserved for over 10 years, my lord.
Not maybe heard, my lord, but some date may be fixed.
It could be heard today, my lord.
Are they working today?
Please, my lords.
What is the designation they have?
They're all staff nurse, my lord.
The administrative staff.
Nurses, my lord. They're all nurses.
What do you say?
Yes, my lord.
What do you say? And they are all working today?
Please, my lords.
And what is their age? Are they
They are-
nearing?
They've all crossed the
No,
age.
they are-
They've,
Not they
they're
are
part,
working,
my lord.
not they were working not in the hospital as a staff nurses on temporary basis. Not they filed.
For how long they have been working?
Ma. Huh?
More than 10 years, my
More
lord.
than 10 years.
But are they eligible under the rules?
My lords, they had to be recruited, I mean, regularized, my lords. Now what they're saying is we are coming up with a special rules. But
There's
that
no-
is no way
special-
benefiting us.
not-
That is no way benefiting us, my lords.
No special rules have been framed by the government, not act. Therefore, my lord, their contention that they are coming under the special rules for regularization, my lord, has to be considered by your lordship as to in the appeal.
But you are not terminating.
No, no,
You're not, just listen to us. You're not terminating them.
they are not terminating. They are still working now.
How much, what is your age? Are you nearing the retirement?
No.
My lords, we are all 45, 48, 49. We are in of that
What
age,
is the retirement age?
60, my lord.
60 years,
60 years. You have time in the sense that.
60 years.
And what are the wages you are getting?
My lords, not the same as the regular employees.
How
my
much you are
lords.
getting?
I think it is about 30,000 or odd, so my lords.
Also, you should not say that. Are you clear?
I'll. 33,000 they are receiving, my lord, whereas the regular employees, they are getting 86,000, my lords.
That we will look into. Today they are not terminating your service.
Yes.
They are working. Huh?
Please, my lords.
The employment is secured. That's right.
Please, my lord.
Now, what is the difficulty for you to argue? Who appears in the other
Lord,
matter?
State
Yes,
my lord
ma'am.
has
State
preferred.
government, state is also filed, my lord.
You are appearing
Four,
for the.
four,
I am for the institution, not for the.
Oh, now, what is the difficulty?
Lord, a date may be fixed, my lord. I appear for state. In 9.2, my lord, 446 is preferred by state, my lord.
Have you framed any rules?
Not state has to argue, not.
You have to tell us, ma'am.
How many matters got adjourned before hours?
Lord, may I submit, my lord? A date may be fixed, my lord. Will argue the matter. Age is appearing. That apart, my lord, the petitioners, my lord, they don't fulfill the eligibility criteria as laid down in Uma Devi's case.
No,
They're appointed against the sanction post.
they are, my lord.
Yes, I will argue, my lord.
Ma'am, they have not come on their own. You have appointed them, they got the employment.
And moreover, my lord, the institute
But
did
the
not have.
state is not the
C&R
appointing
rules.
authority, my lord.
What did you say?
C&R rules were not framed, my lord, as such.
There were no rules at all.
No, my lord, it was not.
Have you framed the rules now?
My lord, on that, my lord,
Yes.
they have.
Just say that at the request of counsel for the appellants in both the writ appeals being 276 and 446. Adjourn to just have it after 2 to 3 weeks.
22-4.
Okay,
It may be said as finally, my lords.
just be prepared, please.
Yes, my lord, please.
Next,
Certain objections are also, we'll clear them.
in the meantime, objections, if any, be shall be removed in the writ appeals.
Number 10.
Much obliged, my lord.
Obliged.
The appellate, my lord. We have filed the paper book on Friday, my lord. Here for the respondents, we've received it, my lord. We may be permitted to file a short synopsis and authority. Appeal has been admitted on the last. Paper books have been filed? Yes, ma'am. Paper books stated to have been filed, the same are not in court. Then the counsel to ensure the same are brought on record. The counsel for the party state they shall file written submissions, be filed within 4 weeks. Let's give it in June.
17-6,
Wait for a minute.
serial number 11, Ajit. 11,
Yes, Mr. Chinnappa. The service effected on the respondents.
Yes, but we had it served, my lord, on the councils. Your lordship directed us to serve it on the councils who appear.
Just show us that, man. Is the service effect? No, Acha, you have, there is no court notice.
No, no court notice.
You appear for whom?
Respondent, my lord.
Which respondent?
17.
Respondent number 1, my lord.
Who are the other, who are the party, who are the to be served, Mr. Chinnappa? Other, in fact, everyone has to be served, even the.
Yes, ma'am. They were all represented by one lawyer.
The
and-
appellant and not the appellant, the
Yes.
appellants and the respondents.
Yes, ma'am. All of them were served through one Rohit Sethi is the power of attorney holder for all of them.
Yes.
So, my lord, and the council, my lord, is one Anita Abraham, who was served by us, and she appears.
You appear for whom?
Respondent number 17, my lord. Apologies.
What is the name?
Bharat Infratech Private Limited.
They are the owners of the property.
Huh?
They are the owners of the property, my lord, who gave that undertaking.
You appear, have you got the review petition?
Please, my lord.
You have got it?
Yes, my lord.
Now who else have to be served?
The appellants originally, my lord, were R1 to R16. The appellants in the appeal, my lord, if my lord kindly takes the order. at
No,
page-
see, we have 1, 2, 3, 4. Then they run till 16.
Yes, my lord.
Then Bharat Infratech,
He is,
then Gold City Builders.
yes, ma'am.
You represent 2 also? No,
No, my lord, only 17, my lord.
17. Then how would you serve them?
We served, my lord, the council who appeared in this court in the commercial appeal.
You have instructions.
No, my lord.
Now this respondent is also contesting party, inter se between
He's a
them.
contesting party, my lord. As a matter of fact, he is the owner of the property. I developed the property. And the persons who filed the suit are R1 to R16. They are the ones who sought an interim order from the court. And not an interim order was granted directing us not to alienate and all of that. Therefore, more than them, it is those parties, my lord, who will have to be there.
Have you served them the copy?
Yes, my lord. Council has been served. We filed a memo along with, maybe her name may
No,
be shown.
suppose we,
The lordship direct the name of the council to be shown in the cause list, my lord, she may appear because page 26, my lord, is the order.
effectively the directions is against you.
Yes, it's direct, effectively, my lord, though I was not a party to the proceedings.
Just say that Mr. Chinnappa, Lana senior counsel appearing for the review petitioner states that the copy of the petition had been served on the counsel appearing for respondents 1 to 16.
Yes, my lord. Miss Anita Abraham.
1 to 16, Miss Anita Abraham. And also to the respondent number 17 and 18.
Yes.
Separately,
Yes, my lord,
separately.
separate, because council is different.
So we find that so-and-so advocate appears for respondent number 17 who states he doesn't have any instructions. He prays for time to take instructions. If that be so, comma appropriate shall be that notice be issued to respondents 1 to 16.
So the lordship direct the name of Anita Abraham to be shown because she won't know it's listed today.
But last time we said so, Mr. Chinnappa. Last time. Or you just say that appropriate shall be that a fresh copy of the review petition be served on Miss Anita Abraham, who we are informed is the counsel for respondents 1 to 16.
Yes.
Additionally, what about 718?
18 also, my lord, my learned friend only appears in the trial court. Maybe he
Don't
can.
appear.
Only I am appearing for only 17 minutes.
But you have instructions.
No, I have no instruction for 18.
You
like,
take instructions for 18.
Please, my lord.
Just in the earlier para, additionally, the counsel appearing for 17 shall also take instructions whether to appear for respondent number 18 as well. Okay, re-notify the review petition, or just give it in April, ma'am.
24/4.
Next,
Can I have?
what is the date there?
The only reason is I am now not having spent all the money. I have a construction.
What is the date there?
In the trial court? 20th.
20th of
March.
Oh. The 20th March, whether you will be able to serve them or we will have it thereafter.
Immediately after, my lord. So
Just
I
have it
serve the
in week
counsel.
of March, April.
8th April.
Wait.
Next.
Serial number 12, Shrimati Sri Rajshekar.
For the respondent notes.
Maintain.
lords, due to an emergency call, senior had to leave, my lords. He's requested for day after Wednesday, my lords. I have informed my learned friend also, my lords.
At the request of counsel for the appellant, re-notify day after to court.
Please, my lords.
Okay, there is an issue of maintainability. You have seen that?
Yes, my lords.
You must look into that.
Please.
Yes.
Public.
12/3. Serial number 13, Shrimati Vidyalata.
We are ready, my lords, both of us.
Very short
Fact-
issue.
Very short point for consideration of this honorable court. Factually, my lords, there is no dispute between us. It's only the question of law, my lords, which your lordships has to decide in this matter. So if your lordships would be kind enough to hear this matter, it's about court officers of this honorable court, my lords.
I will not take more than 3 minutes.
Yes.
Grateful.
My lords, respondent numbers 1 to 13, my lords, are all court officers, which is not in dispute. It's also not in dispute, my lords. Respondent number 13 is junior to respondent numbers 1 to 12.
No, just come once again.
Respondent numbers 1 to 13, my lord, all
Uh-huh.
court officers of this honorable court.
1 to 13.
13, all of them, all the respondents. It's not in dispute, my lords, that respondent numbers 1 to 12 are juniors to respondent number 13.
No, seniors.
I'm sorry, seniors
Seniors.
to respondent number 13. Respondent numbers 1 to
What are the final directions given?
final direction is for
remand back.
remand.
Remand.
Yes, my lords. Kindly, my lords, to clearly explain this matter, my lords, could I request your lordships to go to page 174, my lords? I've laid it, I've given a tabular form as to what has happened, my lords. Why this disparity? Now, respondent number 13, my lords, is getting a higher pay scale than the respondent numbers 1 to 12, who are seniors to him, my lords.
What
That-
was the claim, Mr. Prabhu? Your claim was before the learner single.
Parity, the pay parity.
Pay parity.
What I have said.
Because all of them are court officers.
Now, this,
So-
this pay parity doesn't have to deal with, doesn't have any bearing on the seniority, anything, nothing of that sort.
We are seniors. So all of us are seniors, my lord, to the 13th
You
respondent.
are not getting.
Sorry.
You are seeking pay parity from which date?
From the date of, my lord, the adoption of the central pay scale, when the disparity occurred. It was retrospectively, my lord,
From which
affected.
date? What is the date?
2008, my lord, I'm sorry. The date, exact date,
18, my lords, was the rules which came into force and action.
But
Which came
retrospectively,
into force, my lords, 6th October 2004.
yes, from
That
that
is
date.
what created all this problem, my lords. Though, my lords, they were,
Problem is the pay disparity.
yes, Yes, because
The juniors are carrying,
they
getting
are
more
getting
pay.
more pay than only respondent number 13.
There are others also, one or two
There-
others are also there. I have mentioned in the objection statement, but she's right, my lord, when the learned single judge, we had only vested one. But we
Now
discovered
let's
that
see,
there are
let's
few
see
more.
the memo.
Kindly see page 174, my lords. I'll explain what happened and why this disparity is there.
Hmm.
My lords, Annexure B, my lords, pay rules, the central pay rules, my lords, came into force in 2018. But they are to be considered to be with effect from 6th October 2004. So from 18, we had to redo, my lords, from 2004.
Why so late?
This-
No, 2018 were which rules?
The central pay rules were adopted to our,
See, every 1196. Then after 1196, 2006,
yes, my lord.
2006, 2016.
Yes, my lord.
These were the pay scales of the central government.
Yes, my lord.
Okay, now which pay scale you are referring to?
So,
See, we
fifth
have,
pay-
no, I don't think so. From 2018 would relate back to 2004.
yes, my lords, kindly see page.
And which pay rules under the central government were given effect from
This was the
2004?
Fifth pay commission rules were.
That's
given.
1196.
Yes, my lords, that was given effect in the year 2018 for us, my lords, for our.
So what was happening in the interregnum?
Interregnum, we had the state pay rules.
Oh,
Only in the year
think state pay
2018, we got the central pay rules on parity with the central.
now from in 2018, everyone got central pay
Yes, everyone got.
from
but
2004.
So-
Everyone or some of them?
Everyone, all of us, all of our staff,
All of the staff.
all the staff,
Now we are concerned with court officers.
only the court officers.
Now some court officers, although some court officers got it, the benefit from 2004,
Yes, my lord.
that's right.
Yes,
There are some like the respondents herein,
yes, my lord.
they were not given the benefit,
No, they were given the benefit. What
but there is a
happened?
disparity in the pay.
Yes, but can I request your lordships to go to page 174, my lords?
How much is the, just take for instance, this gentleman Uma Shankar,
Yes, my lord.
174. Now his fixation is so you did not get fifth pay from 1196.
No, we got from 2004.
2004
Four.
and block everyone.
Yes, yes,
So that's the date.
that's
Is
it.
it 1120, 2004?
6/10/2004.
6/10/2000.
Yes.
So pay fixation under the central government
Yes, my lord.
was done on 6/10/2004 for all the employees
All the employees.
in the relevant grades.
Yes.
Okay.
And some of them had retired, some of them were promoted. So we had to redo the entire thing.
Everything.
Yes,
Now, insofar as this issue is concerned,
yes,
though in regard to certain officers,
yes.
the fixation was done even in the case of the
Everybody.
everyone.
Yes.
But for some officer, the fixation was high, the some officer fixation was less.
Yes.
It
Uh,
is that which you want that it should be removed.
Which they want to be removed. They say it's only because of the central pay. review.
Show us from there.
Kindly see page 174, my lords.
We have 174.
Uh,
Now, how would you explain? We have two officers, Uma Shankar and Nataraj.
Yes, my lord. Uma Shankar and respondent number 2 is the Natarajan. This
Hmm.
is, my lords, he is appointed on 16/1/97.
Hmm.
And the 13th respondent, 13/9/2000. He is junior to him, junior to all the
Who is
respondents.
junior?
Respondent number 13, my lords, is junior to all the other respondents. Who is now getting a higher pay than respondent numbers 1 to 12.
What is the name of the 13?
Nataraj.
Nataraj, my lord.
Acha, Nataraja. Now
Nat-
tell us one thing, what was the pay fixed on 6/10 insofar as he is concerned?
Your lordships may see.
Page one.
Page
164.
164.
164 and 165.
Hmm?
164, column number 3, my lord. The pay as per the second column, lord, is the pay as per state.
State pay.
Next column is, my lord, the pursuant to the adoption of the central pay scale.
Let's make.
Ah, 610. If you see the right-hand column,
Yes.
serial number 2,
Yes, my lord.
stenographer in 3, then this,
Yes, my lord.
then fixed at SEMO 610, 5,500 with effect from 610, 2004
Yes, my lord.
in the pay scale of this.
Yes.
Okay.
Well, that's
Now-
what happened was, the same page your lordships may see, 164.
Hmm.
My lords, Nataraj was promoted, my lords, from the typist cadre to stenographer cadre, my lords, by passing certain examinations. Stenographer and first division assistant is one same cadre. He passed some examinations, my lords, and he became a stenographer from the typist cadre on 17/10/2003.
Hmm.
The petitioners, my lords, the other respondents, were promoted as first division assistant only, my lords, on 9/7/2008, which your lordships will get at page 165.
The Harishankar, Umashankar.
All the other people, they were promoted, my lords. This was a normal seniority promotion.
And where exactly this disparity arose?
This is where the disparity occurred. Because 2003, my lords, he was already getting a higher pay scale.
So that
from
higher pay continued Umashankar.
It continued. But when it came to the court officer cadre under the state rules, both of them drew 10,000 only. The pay scale came down to 10,000 for both of them. But when the central pay scales was adopted, we had to redo, my lords, from 2004. So he was a stenographer in the year 2003 itself. So when we redid, my lords, when we came down to
Because of the fact that he was a stenographer, they were typist.
Yes.
His fixation was high.
Fixation from 2003 to 2008, my lords, that fixation difference is there.
That continues.
Continues in the central pay scale. And that is admitted, my lords. Now what they are saying is just this. All of us today are court officers, and hence we must be getting same. That cannot happen, my lords. If if it is interfered by this honorable court, my lords, central pay has to be adopted the way it is being given, my lords. If we change one person's, there'll be a katana of cases, my lords. All cadres, such discrepancies are there.
Which is that provision which deals with the stepping up of pay?
6B.
Effectively, this is
State
stepping up
rules.
of pay.
Yes, 6B of the rules. Sure, lordships will.
But tell us, Mr. Prabhu,
Yes,
you have to go to the genesis of the disparity.
yes, I'm answering that particularly. That is the only issue. May I persuade your lordships to see Lord 164 itself for a moment? If lordships see that Mr. Nataraj's pay scale, lordships may see he was promoted, no doubt, from the cadre of stenographer. My lord, his pay scale was 4150 as with effect from 18/10/2003 in the pay scale of so and so, so and so. Then, my lord, he was promoted as the assistant court officer. If he had continued in the state pay scale, his payment would have been, my lord, 10,000 with effective 1/8/2009 in the pay scale of so and so, so and so. Lordships may hold it for a moment. Then now juxtapose it with Mr. Umashankar and others. Next page, my lord. When I was also promoted from first division assistant to the assistant court officer, serial number 3, my pay scale also was 10,000, Umashankar and others. And if this had continued, lordships may see 22,800. Then, my lord, in the previous page also 22,800. So all that I'm saying is, if the state pay scale continued and the central pay scale was not adopted, then it would have become 10,000 and 22,800. My lord, if my learned friends,
For both.
both, if, my lord, my learned friend's logic is to be adopted, that he was promoted from the cadre of stenographer and his promotion was earlier, it was a feeder cadre is different, your feeder cadre is different, then, my lord, the 10,000 is common. Once I am promoted to assistant court officer, whether Mr. Umashankar or Mr. Nataraj or any other, if, my lord, the stenographer is the basis, if that is the criterion, then this 10,000 should have become 12,000 or 14,000. No.
No, Mr. Prabhu.
Please,
It's like this.
please.
Promoted 10,000.
That 10,000, my lord, if lordships may ignore that last column altogether, my lord, close that column altogether. Kindly see, my lord, pay fixed as per Karnataka pay scale only. If this central pay scale was not adopted, And if the state pay scale itself was
We
continued,
got your point. We
yes,
got your point.
and therefore, my lord, page 58, 57, your lordships may see, 58, my lord, to be.
But tell us, no,
Yes,
you look it in a perspective.
yes,
Now you have both the charts.
yes,
164,
yes,
this gentleman, Nataraja,
yes,
he was promoted as stenographer and his pay was fixed at 4150 under the state scale.
yes.
Okay.
In my, no,
That's
also,
one.
yes,
Now, he continued in the state scale till 6/10/2004, when his fixation had occurred under the central scale.
this was, my lord, retrospectively, that 10,000 in page 164, your lordships will see. Now, my lord, kindly ignore the central government pay scale altogether.
Got it?
Yes,
We got your point.
yes,
Now, 10,000, see, so
If-
if you see his fixation of Nataraja,
yes.
6/10/2004, it
Yes,
is
my lord.
5,500 under the central scale.
Enter, yes, 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 yes,
Okay.
yes,
Now, what you are saying is,
Yes.
when he got promoted,
yes,
serial number 3,
yes, my lord.
okay?
Yes, my lord. That's
Serial number 3, though fixation is at 10,000,
yes,
though scale or this is 10,000,
yes.
the fixation is at 17540.
Only because of the adoption of central pay scale.
No,
It is.
it would not be. It would be because of a higher fixation because of stenographer.
Yes, may I answer that? my lord? If that is so,
Huh.
I'm answering that pointedly, my lord. If that is so, then his pay scale under the state rules itself would have varied. Now, my lord, if that's why I'm not requesting your lordships to kindly ignore the last column altogether, which is only notional, which is only adoption of central pay scale. Now, suppose, my lord, that is not adopted. I just close that, my lord, with my right hand. Only if your lordships were to see the state pay scale, his pay scale and my pay scale would have been same. Now, my lord, if it is because of his passing of stenographer exam or for any other extraneous reason, then, my lord, they should have varied his pay scale or they should have put higher pay scale right at the state pay scale level itself.
You are right.
Yes,
But the answer possibly is,
please.
when he got promoted, his fixation was 4150 under the state scale.
Yes.
Natarajas.
Yes, which became 10,000.
No, 18/10/2003.
Yes,
Okay.
yes,
Now, this 10,000, what you are referring to,
yes,
even in this case also, if you see Nataraja promoted as 10,000,
yes,
with effect from this.
yes,
1/8. Now, what they have done is they have not fixed his in 10,000. 10,000, it appears to be a normal pay. He would have got it if he had continued under the central,
yes, my lord.
under the state.
State.
But the fixation is on the right-hand column under the central.
That is consequent to adoption, my lord. That is the anomaly, which page number, my lord, 52, 58,
Okay, we will put
yours
it,
to, yes,
we will put it this way.
please.
Are you saying
Yes,
if he all had continued under the state government,
yes, my lord.
even Natarajas would have been fixed at 10,000?
It is fixed, my lord, already fixed.
Is it so?
Yes, 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 yes. That is what, my lord, is the whole issue.
Then what he is saying is what, how would you answer that?
That's all I'm saying.
But my lord.
And therefore, my lord, I'm sorry, my lord, I'll complete this logic. I'm so sorry. Page 58 addresses it is an antidote to the very same situation.
But tell us one thing, we have not understood subject to what they say so.
Yes.
You are a typist,
No, I am, my lord.
stenographer,
Yes,
but the fixation, how can be a fixation at 10,000 for both?
because the feeder cadre is, my lord, assistant court officer. For assistant court officer, there is a particular fee, particular pay scale. Whether I am promoted from this cadre, feeder cadre or some other cadre.
This 10,000 is assistant court officer.
Yes, my lord, that's what I am saying. Assistant, and next also, lordships may see the next column.
We have seen.
When we became court officers also, our pay scale would have been 22,800. Her pay scale, sorry, the 13 respondent also 22,000. Came assistant court officer. The moment the central pay scale came, whether it is because of, my lord, the stenographer examination or for some reason.
Ma'am, just
This,
now tell us one thing. Once the fixation
yes, Kindly see
ACO,
I've
even-
received the entire fixation, what has happened.
Then why don't you undertake this process which the single judge has said?
And
Why don't you
No, I'll
undertake
just-
this process?
I'll just complete the loop, my lord, with
It
one
has
more.
been done, it was.
In terms of the single judge?
No,
Even before it was done, it was brought to the notice, my lords. That's what I'm producing it before your lordships. My lords, we kindly see what happens, my lords.
just complete one more logic, my lord, and my learned friend can answer that also.
My lords, this 4,300. Kindly see the difference, my lords. It does not arise, my lords, with the court officer. It arises much earlier in 2003, 2004.
You're right.
Yes, my
but
lords. Yes, my
What
lords.
is sought to be urged is this. If the disparity has come
Yes, my
at the
lords.
stenographer stage,
Yes.
that disparity must have been reflected when you fixed at 10,000.
It was there, but the 10,000, it was not there.
Why?
It vanished in
Why?
10,000.
Why?
It vanished in 10,000.
That's
I did vanish.
I really tried. It
And the
vanished in
And the
10,000.
answer is there lies.
It
that is the
vanished,
heart
of
it
it.
vanished. It
If
did
there is a
vanish.
higher there, it should be reflected at 10,000 stage.
Yes,
Something more,
it did
Ah,
not
Nataraja
reflect
was
either.
getting-
That's the whole point.
It did
That's the
not
whole
reflect
point.
either in the assistant
And-
court officer cadre or the court officer cadre.
Correct.
My lords, but my lords, could I just take a day's accommodation to find out if there would be a change? If the state pay itself would have continued, if there would be a change, I'll,
that's
Their
what
own
we want
document
to,
then.
I will
that's
just-
what we
I
want
will
to
just-
ask.
but
Find
the
it.
fi-
If the state scale had continued,
that I'll find out, my lords.
was that fixation for 10,000 of Nataraja was not correct?
Even I told them
And
it is
these
not
are
correct.
their documents.
It is not
I-
correct.
These are their documents. I am not
Kindly
producing.
see, my lords,
Then,
kindly see
Mr.
that.
Prabhu,
Kindly see that.
if it is not correct, it has to undergo a change, then your very foundation of disparity would go.
No, my lord, may I submit this? The page 58, I'll just complete this loop of logic. Page 58 is the state, 57 is the, my lord, state rules. 58, 6B, your lordship sees kindly, my lord. 6B, the service conditions, am I reading with your lordship? Page 58. The service conditions of the officers and officials of the High Court, apart from the salary allowances, shall be as per so and so. Then, consequent upon adoption of central pay scales, am I reading with your lordships? 6B, my lord. Consequent upon the adoption of central pay scales and fixation of pay to the officers and officials of the High Court of Karnataka, anomaly, if any, shall be cured after obtaining necessary orders from the Honorable Chief Justice, High Court. Now, this order that lord is impugned is the order passed by the Honorable Chief Justice. Now, if the order is passed in terms of this statutory mandate under this, lord, can somebody file an appeal and say the Honorable Chief Justice should not have exercised powers under 6B? Now, my lord, it is a statutory exercise of power. Unless it is shown that it is.
No, but
totally-
are they contesting that?
Yes.
No, are you
That is what is. Lordships may see the operative portion of the order, my lord. That's why, my lord, I'm completing the loop before my learned friend answers. Lordships may see page 38. Memo dated so and so. That is, my lord, impugned before the.
We feel,
Yes. This is, my lord, Honorable Chief Justice order.
it's all right, doesn't make any difference.
No, I'm saying, Lord, the same exercise of power under 6B is this order. And it is said, my lord, that remitted back to the first respondent to reconsider the
Has
case.
to be done at the High Court level.
Yes.
The Honorable the Chief Justice being there, the competent authority has done. Now tell us one thing, ma'am.
Yes.
Why don't you, ultimately, what is it, the order of the learned single judge? He has remitted back?
Can I take you
Yes.
to the statement of objections? My lords? I've written very clearly what has happened. In order to address the issues raised with the representations made by the petitioners, which is furthered in the above petition, we had, my lords, Honorable High Court Staff Committee and the Honorable High Court Chief Justice, my lords. They have considered it in detail and they've already rejected it. Now,
That is
if
previous.
it is again sent back, it's the same, I'm just making it things easy.
No, after this.
Yes, ma'am.
Now, very well.
It-
So tell us one thing, this exercise has been carried out after the impugned order?
Before,
Now,
Before.
Mr. Prabhu, you sit down, unless and until we call upon you, you will not.
I'm supporting my learned friend. I don't.
No, I'm so sorry.
Then where is the dispute now? If you are supporting, that's the end of it, you withdraw this.
No, my lords, because it's not only in the court officers cadre, my lords. This disparity, my lords, is there in all cadres. Only because, my lords, from 2018, we had to go back to 2004.
Tell us
We
one
had
thing.
to redo everything, my
Tell
lords.
us one thing. Whether you could have fixed Nataraja at 10,000 after the state.
That I have.
Did anyone looked into that?
I have told them it's erroneous. I've told them 10 times it is erroneous.
Did you look into that?
I told them, I'll find out, my lords. What they
Do that.
I'll do it.
If that anomaly goes, I think everything will fall in
Everything will
place.
fall in place.
Then possibly, their argument of disparity would go. Your case would be this disparity has arisen because he became stenographer and that continued.
But continue. Your lordships, I got the entire calculation, my lords. All
You must look into
until
this.
this
No, my lord,
assistant
that-
court officer, there is a difference. As soon as this 10,000 comes, they fix it, the state pay, it fixes at 10,000.
May I?
He's 1 minute, Mr. Gupta.
Sorry.
He's right in.
Yes,
If
yes.
he were to be in his position, we would have also
Yes.
said 10,000, 10,000, 10,000. That's all.
That's what has
But
happened.
may I answer that, my lord? That
If-
does not negative. That does not negative, even presuming for a moment against me, my lord, that now they say that the actual 10,000 fixed as per the pay scale for Mr. Nataraja or any other employee itself is wrong. And then we'll cure it. That also will not make, I'm just, my lord, presuming and answering.
Why?
Because, my lord, the learned single judge says, all that the learned single judge says is, looks, there seems to be an anomaly as it exists today. What needs to be done in future, my lord, is another issue. When it will come into effect, whether it will take prospective effect is another issue. As we stand today, 10,000 is a reality. It is paid not today, but from 2018 onwards, from retrospective effect. All that I'm asking is, my lord, whether this action tested on the anvil of the central rules and the power of the Honorable the Chief Justice is correct or not. And the order, my lord, will not be
You are right.
negative.
You are right. As the thing stands,
Yes,
clearly argue that 10,000 is for everyone. So they cannot. Now we are putting it to you.
yes,
In fact, that's what we are putting. We are putting it to you. A person who has a higher pay before the central government was, 1 minute, Mr. Prabhu, you will
Yes.
listen to us.
yes, I'm so sorry.
When Nataraja was getting a higher pay as compared to Uma Shankar,
Yes,
hypothetically,
yes,
before the central pay was
yes,
given,
madam.
when actual fixation takes place under the central,
Yes,
is it not logical
yes.
that
He should have got more.
Nataraja should have got higher pay?
I'm answering that pointedly, my lord. Kindly take 164 and kindly take his pay at serial number 2, my lord, in column number 2. Promoted as stenographer, then he was getting 7,800, the last number on page 164. Now, kindly see, my lord, my pay scale, which is 14,800 as compared to 7,800.
That is 2008, my learned friend.
Adane, Adane. Now, even before, my lord, his
My lord.
stenography, I'm answering that pointedly. If, my lord, if it is an innate feature that his pay scale is more for some reason, whether he passed stenographer exam, he has taken, we have also taken exam. That's another issue, my lord, that we have also taken stenography exam. What happened, my lord, that we have in fact, that is not the basis. I'm not claiming the disparities on account. This one itself, column itself may be taken. He was drawing 1040.
When were you appointed as the court officer?
That is, my lord, on
15/4/2000.
yes,
No.
15/4/2000.
1/8/2009.
Uma Shankar.
Sorry, my lord. 15/4/2013. 15/4/2013. Which is 13/3/2014 is Mr. Nataraja. That is also.
Request your lordships to just look into this table which I just said.
Was Nataraja appointed as assistant court officer before you or after you?
No, that was, my lord, 13/7
Together.
almost one day here and there.
Together.
Same. 31/7/2009 minus 1/8/2009.
Together.
Leave that. Court officer. I'm sorry. Then
But your pay even under the even in the state scale,
yes,
uh,
was more.
No.
even
kindly see,
on 9/7/2008 was
Yes, my lord. 14,800.
that's 8,000, 14,800.
Yes, and kindly see, my lord, the previous page.
One
Look,
minute, Mr.
this-
Prabhu, just
this-
1 minute, ma'am. Your pay between 97 and 2008
Yes.
was 1040. Are we right? Come to, we are not, we are saying when you are saying you, we are comparing Nataraja with Uma
Yes,
Shankar.
yes, Uma Shankar and others. Yes,
Come to Uma Shankar.
yes, my lord.
Uma
160.
Shankar was 1040 in 1997.
Correct, correct.
The next promoted he got was only in 2008. In between, he continued as typist.
Yes.
Correct.
Now, as compared to this, see the gentleman Nataraja.
2003.
2003, he was typist.
Yes.
2003, he became stenographer in a higher fixation.
Right.
It was 3,054 5450 and
Correct.
4157.
Please. That is because, my lord, he could not have become a court officer. Then as a chance entry, my lord, he
And
became
they-
later. Anyways, that is, my lord, I bowed down.
You will
But
look
the-
into it.
To that, may I take your lordships just to the table minutes for a second? Could I, this table which I just gave it. Just to show the comparison in the state pay only. The first column, my lords, is of Uma Shankar and others. The second is my lords, respondent number 13, Nataraja. My lords, they started with 3550 and 4250. My lords, in 2004, my lords, he gets 4250. They were continuing at 3550. It went up to 4350, 4350. They were continuing in 3000, my lords. He gets 8400. They get 6800.
So, ma'am,
This continued up to my lords, assistant
ACO.
court officer.
Correct, correct.
so
I'll find.
you find out that fixation at 10,000 is
Yes,
appears to be something amiss. You look into that.
I'll do
So
that.
as we stand today, my lord, as your lordships are now examining whether this action is right or wrong, this order may be affirmed. Subsequent to that, my lord, they may erase the very foundation itself, which they are entitled to.
No, I can't be. When the learned single judge has remitted back,
Yes,
they will look into everything and then we'll work it out.
that's all I'm saying, lord.
We'll
Let
work
that be.
You will look into it.
Huh.
And you feel that there is some issue on that fixation of 10,000.
I'll do it.
Then you, on the strength of the learner single judge
Correct.
judgment, you will
Huh,
work it out.
exactly, my lord. That is
But-
what I'm.
It
Before you
may not necessarily mean, Mr. Prabhu,
Yes.
that whatever you are saying, they may agree with you.
No, I bow down. Lordships may seem, lord, the very reasoning they may efface. They may say that 10,000 fixation for Nataraja itself was wrong and that should have been 20,000, whatever. I'm just saying. Lord. And your pay scale should be 15,000 because you did whatever, let them do. But as the things stand today, my lord, what prevents them? That's the whole point I'm making.
Well,
What prevents them from acknowledging the order, doing whatever they feel logically is correct. And then, my lord, that will give rise to another cause of action.
And even today, we say, ma'am, on the strength of learner single judge, there is no need for you
Ah.
to independently look into it.
Yes, please.
On the strength
Strength
of that
of-
order, you can still do it.
Deriving
Do it, but-
strength
but
from this.
I'm just helping my
Exactly.
good friend because I don't want the same order and I don't want him coming back
Same
again
order,
with the same,
She is not.
because this is.
No,
this
lordships
aspect
are
has
saying
already been
something
looked
else.
into. This aspect has already been looked into, my lords. These representations, my lords, were extensively looked into. They were calculated, recalculated, and they were done, my lords, under all
Are we to-
committees.
Are we to take it that 10,000 fixation is right?
That I will make submission,
No.
not that part of it, but
Ah.
the part of fixation, my lords, under the central pay for both of them is correct.
Their
There is-
fixation, no, their fixation, everyone fixation is
Yes.
right.
Yes,
But we have to see the fixation of this gentleman, Nataraja was right or wrong.
yeah, only on 10,000.
Because they are seeking parity qua him. Just say at the request of counsel. for-
Possibly, my lords, what happened was
If I were in their position, I'm just saying it with all humility. Let them consider, as your lordship suggested now, what fell from your lordships on the strength of the learned single judge's order and also what fell from your lordships now. Let them reconsider it and, my lord, come back with the solution
it has already been considered.
and which may be disposed of.
Place it, why this 10,000, my lords, then
Then,
your
ma'am,
lordships may
either
take.
this thing, either you yourself personally feel this 10,000 appears to be something amiss.
I will take instructions, my lords, so far as only this part.
For that reason, my lord, I'm saying, my lord, let it be disposed of. Let her, my lord,
All
consider
right, with a 2 day, 3 days, she will take instruction.
Ah,
Mr.
2 days.
Don't vanish, I'll just
No,
asking for
Saying,
Wednesday or Thursday.
Just say that at the request of counsel for the
Wednesday.
appellant. When do you want?
Wednesday or Friday.
Wednesday or Monday? Wednesday or Monday?
which one they should? Lord, written arguments and judgments.
No need for written
No
argument.
need.
Yeah,
of-
just, Lord, for my satisfaction.
Don't be this.
Served it.
You will have Wednesday, we'll have Wednesday.
Yes, I'm just saying, my lord, for my satisfaction.
What is that?
No, written arguments and.
Let's see. Keep it with you.
Okay. Right. Please.
This disparity, my lords, arose because from 2018 to 2004, we had to redo it, my lords. From 2004, we had to redo. So all the things changed, my lords, from 2004 onwards.
We got it.
That is because not only with the court officers, my lords, with almost all cadres, this kind of disparity is there because we had to take it in toto. 2000.
It appears you saw the designation assistant court officer as you are fixing for all assistant court officer 10,000
10,000 they fixed it.
without realizing that
he
the
had higher
gentleman
pay.
was higher pay.
Higher pay.
Possible.
But my lords, his was 9,050. So it was lesser than the court officer's
May I
pay
answer that?
scale, which was 10,000.
May I
So
answer?
they could not have increased it. That's what they possibly must have done, my lords. The lowest was 10,000. He had not reached the 10,000. He was 9,050, just little lesser.
But you
So
must
that was-
ask them with this pay of Nataraja, with this pay of this gentleman, other one, what should be the fixation at court officer level on 6/10/2004?
My lord, may I?
Yes, my lords.
One pertinent fact I wanted to bring to your lordships. The cadre as Mr. Nataraja, my lord, who were the stenographers, did not have an entry into ACO. The assistant court officer was open to only my cadre, where FDA, etc., were permitted. A window was opened, and 3-4 people got into this. So therefore, my lord, when there was no entry possible from stenographer to ACO, there was no question of fixing a higher pay scale for ACO because the window itself was not there. Only for that year, 1 or 2 people, 3 people got in.
Right, Mr. Prabhu, that you can't give.
The rules are. not
Rightly
changed.
or wrongly, he has become ACO.
Correct, my lord.
That's right.
Yes.
Then it has to be tested on that and will only. He is an ACO. He was a stenographer. He was drawing a particular scale. What should be the fixation?
It's not a lateral entry. It's a different entry.
Not a lateral entry.
Allah, only there was no entry possible for ACO. I'm reiterating that.
But tell us one thing, will that make any difference?
It will not, because I'm submitting with all humility. Whether he is a stenographer, whether he is somebody else would not matter at all. Once I'm ACO, my function is same as that of the ones who came from FDA cadre, SDA cadre, or whatever cadre.
Everyone is ACO.
Everybody is ACO, same work, same payment.
Similarly placed.
Whether as a stenographer, whether promoting to ACO should have entitled him for more, this one or not, would not arise because that entry itself was not there. That could not have been thought over is what I'm saying. Only for my cadre, FDA, SDA cadre, that was available.
You see, then you are saying if entry was not there, then why was he made ACO?
It was only, my lord, as a special case. Lordship, my lord, my learned friend may also ascertain that 3 people were given that entry and then it was closed. The window was open and closed.
So the window was given. He has come in.
After 3-4 people, it was closed.
He has come in.
Yes.
He must get the benefit of whatever is.
Then, my lord, no. If they go back and now say, entry point itself, everybody should have revised.
Let her look into it.
Yes.
When is-
10,000, 22,000.
Serial number 14. 14, Chief Chandrasekhar.
Yes.
For the appellant, court fees has been paid, my lords. Court fee has been paid, my lord.
The counsel for the appellant states, court fee has been paid, the registry to check and report on the next date.
10-6. Serial number 15, Ranjendra Swami. 15.
There is a delay. Those 2 other legal aids are now in USA. They are coming in the next month. 8 weeks time may be granted.
What happened, my lord? The third applicant in the impugned order, my lord, he died after passing of the impugned order. My lord, his wife was there, so my lord, she made us a appellant number 3 hearing. And my lord, other 2 daughters, my lord, they are in USA, my lord. They are coming, my lord, in the next month, they are coming.
So what do you want?
I want 8 weeks time about that.
At the request of counsel for.
But it's a whole 450 day, 2 days delay in filing 37,
Just take this.
still under section 37.
But let the LRs be there, man. This is appellant, you're right. But how would you answer the merits of the challenge? Challenge on the merit. It was delayed. The 34 itself was delayed.
There is a delay, my lord.
See, the award is dated 22/11/16 and you filed this in 6/7/2017. See page 24.
But that delay was condoned, my lord.
Not this 34 delay, 34 petition.
34 delay.
See the page 24. You see 6th line, none of the contention made out ever covered on the ground. The impugned award was passed on first respondent on this, and this proceedings was initiated before the court on 6/7. Notice of the award was sent on,
Since the application was filed by the,
was barred by limitation contemplated under 34(3). So how do you answer this? It was not maintainable at all. It was just, would not have been gone into by 34 court.
that I will submit along with application, my lord. After,
So that is right. See, ultimately after 9 months, you filed it. What do you say?
after making their necessary parties, my lord, I will submit on the both applications.
That's what we are saying is, it will not really help you, even if you bring them on record. The fact remains that there was much beyond 3 months, 9 months, you have
9
filed
months.
it. Just say, let him bring on record.
Milord, may I submit, Milord, just Milord to just, Milord asks this honorable court, Milord, as per this, Milord, it says that this was not a delay, Milord. This page 24, just Milord, I am just trying to answer the court. That impugned award was passed by the first respondent on 22/11/2016, and this proceeding was initiated before this court on 6/7/2017. And notice of award was sent on 4/5/2017, and hence there is no delay. Before 34 court, there was no delay. I mean, that is what, I mean, I am reading.
But we have not understood this. The impugned award is this. This proceedings initiated before the court on 6/7/17.
Yes, Milord.
So after 9 months,
Yes, Milord. But they say that notice, I mean, that award copy
Award
was
notice
received by the landowner only on 4th May 2017. That is what
4/5/2017.
court is trying to.
okay, it's all. Now, you have already filed an application for bringing the LRs on record.
That is the wife, my lord, was there, my lord. I filed application along your wife. Wife is in Bangalore, my lord. But the other 2 daughters are in US, my lord. They are in.
Just say at the request of counsel for the appellant adjourned to.
But I hear, Milord, like even under 37, Milord, for delay. Milord, that is covered by, Milord, the Honorable Supreme Court judgment.
I know that also.
So it's a 452 days.
Are you saying the similar limitation would be applicable for 37?
Milord, 30, Milord, yes, Milord, there is a Honorable Supreme Court judgment, Milord. I'm just relying upon, Milord.
There is one judgment of the Supreme Court saying that the limitation should be similar to one which governs 34 and cannot be.
34, 30, Milord, here it is for 37, Milord. This,
But when 34 is limitation is 3 months and 30 days, why not a similar limitation for 37?
37, yes, my lord. So, but here it is a 452 days delay. my lord.
You're right. That's what we are with you on that.
Yes,
That's what we are saying. That's what even the Supreme Court holds in this.
yes, my lord. So that's why. my lord,
No, this is in Borse, brother, right? Here the principle is different. Principle is it should not be a large delay. It's not it's not a negligence. Those are the parameters in
Yes, my
this.
lord. Yes, my lord.
But there is another judgment of the Supreme Court, Justice Rohington Nariman, where he says when the limitation for 34 is 3 months and 30 days, for 37 also should be the similar, though doesn't say, 37 doesn't say, so should be the similar limitation. That's what the Supreme Court says. So there is one judgment of the Supreme Court, we are aware. But how would you answer even this also?
Paragraph
456 is a huge delay. And what are the reasons given by you?
What happened, my lord? Paragraph 63. my lord.
The applicant, DT Raju Lord, he was looking after all the affairs of the cases and family affairs, Lord. Other hard blood, we are illegitimate and we are in looking after lands.
Let the last
Did not complete it.
just say the request of counsel for the appellant adjourned.
53.
Yes.
Srimati Manisha Kangovi.
Well, appearing for the appellants, but the parties are still in the process of looking for a settlement. For the executing court for a decree of 97 lakh, I've already paid 75 lakh. What's the next day
You're
before
exploring
the...
settlement.
Yes, we have taken the possession has been given. It's only the dues now. The due awarded was 97.
At the joint request of counsel for the parties adjourned to.
5, 6,
Much obliged.
17, Shri Akshay Raj.
For the respondent.
Here's the repellent. Need my lord short accommodation in this. My colleague, my lord, was to address this argument.
My lord, on the last occasion, it was understood, my lord, that matter will be listed today for final hearing.
Yes. Let's see.
Lordship disposed of one of the applications for injunction, where the parties agreed for maintaining status quo in respect of possession of the property.
Interests of both parties are protected by this honorable court by granting the modern my lords. Some inconvenience to my colleague who is appearing in this matter, my lords. A short accommodation. And if my learned friend is willing, my lords, we are prepared to go for mediations, my lords. One attempt could be made, my lords, in that.
How much is the liability?
My lords, that is, my lords, a termination is upheld and my lords, and a damages of 5 lakhs rupees has been awarded. What has happened, my lords, they're not taken into consideration, my lords, at 10 lakhs rupees, which was paid to them, my lords, as a deposits. Court has treated it as a out of, my lords, and a part of a joint development agreement because it was paid before joint development agreement. That receipt, my lord, though admitted, that part has not been considered. And only, my lords, today his concern is, my lords, the property value has gone, my lords. Only, my lord, our concern is, my lords, we have spent 29 lakhs rupees, my lords, a plan sanction. We have put a borewell there, my lords, and also paid 10 lakhs rupees, my lords, on deposit with them. That part, my lords, has been ignored, my lord, though, my lords, and admitted fact, the receipt is the for 10 lakhs, receipt is, my lords, and admitted. Only arbitrator holds that it is not a part of a transaction. There is no other transaction other than this with, my lords, my respondent by this joint developer. These are some aspects, my lords, if mediation, my lord, parties could, my lord, resolve that. One attempt could be made, my lord.
My lord, question of mediation would not arise, my lord. In fact, I have myself interfered in the matter and tried to find out this could be a matter could be settled or not. It's a case, my lord, where he is a contractor. He took up the what you call development activity, saying that, my lord, he'll put up flats. More than 4 years, my lord, after the joint development agreement was executed, no progress was made, not even the commencement of the construction was not started. And he did not have the money and means to construct. Therefore, these are all findings given by the learned arbitrator.
Time, my lord, railway track was. going
Termination
on,
has
my lord.
taken
There was,
place.
he cannot take out, my lord, a goods vehicle to the premises itself, my lords, last, for 2 years, my lord.
You want to argue or what?
No, my lords, no, my lords. Short accommodation, there. Since my lords have asked what is the situation, my lord, that's why.
They say that at the request of counsel for the appellant in both the matters. Give it, ma'am. March, April. Give it.
In the meantime, my lord, if your lordship's insisting on the records being called for,
TCRB requisition before the next date.
24/4.
Hello. Interim order, my lord, kindly.
Interim order if any to continue.
Hello.
Yes, Mr. Riga. Yes. My lord, it's under the Land Acquisition Act. The first, the 45 square meters of land in a place called Uppinangadi. Uppinangadi is on the national highway between Bangalore and Mangalore, close to the bus stand. The land was acquired. One is 360 square meters. Another is 55 square meters. My lord, notification is of the year 2014. An award was passed on 23/1/2015, my lord. 5,202 rupees per cent of land is fixed. My lord, whereas nearby land was sold at 4 cents of land at 1,10,000. How much they gave you? They gave me 5,202 per cent of land. That is about 45,200 for the entire extent of 9 cents. That is 360 square meters. What is the basis for you to say 1 lakh?
1,10,000, that sale deed was placed before the,
What is the date of the sale deed?
that sale, yes.
Yes.
That is 2013 is the sale deed. 2013 is the sale deed of that particular plot of land, 4 cents. (26/11/2013) registered sale deed. And that is enhanced marginally to by about 600 rupees, madam. Only 600 rupees by the.
So how much it became?
It became 5,826.
Okay. Now, what is the date of the acquisition?
2023/1/2014 is the notification.
No, the final or the preliminary?
This final.
Preliminary is which date? This 23/1.
Preliminary dates are not given.
Now, where is the sale deed?
Sale deed was placed before the authority, my lord. That
Which
is,
is the page here?
that sale deed I have not placed, my lord, because in MFA we are not permitted to file.
Did you submit before the arbitrator?
Yes, my lord.
What is the finding?
The arbitrator, the finding is that is referred to at ink page 47 in MFA 3736.
Which page, which line?
My lord, it's about
The applicant
12th line.
The
in
appellant
the
produced
section.
sale deed land of 20, which is your survey number?
My survey number is
Said land is sold.
8-18C2 converted land. 18C2.
So it's not close to 22.
This survey number 22 is at Ilantila village, which is about 1 kilometer away from Uppinangadi. This is a converted property inside Uppinangadi town and close to the bus stand. And the arbitrator also further proceeds in the same the award. The acquired lands of the applicants were refused to be converted, whereas it is converted. Records were placed before the honorable arbitrator.
Where does it deal with this sale deed?
In the very same paragraph, one second, that is the arbitrator proceeds on the basis that 3G of the National Highways Act does not permit all that. Then he at page 50, paragraph second, it only says that in the present case, second respondent has determined award based on the provisions of 3G7 of the National Highways Act on the provisions of the RFCT LARR Act 2013. However, section 3G of the NH Act are not taken into consideration. I have carefully considered the facts of the case. Applicants suffer on that, my lord. The land acquired has a good potential for future development. Hence, on account of all these factors, it is considered that the compensation determined by the second respondent is less than reasonable rate. And kindly see the operative portion of the order at page 51, my lord. Order.
Where does he deal with the sale deed? Which
He does not. He does not.
where is the sale deed? Show us. Achha, it's not here.
That is not there. I have a Xerox copy of the.
But tell us one thing, a sale deed which is for a land which is away 1 kilometer away.
Yes,
can be compared to this land?
My lord, that sale deed was placed before the authority to prove that at a place called Ilantila, which is about more than 1 kilometer from the bus stand, the Uppinangadi bus stand, was sold in the year 2013 at 1,10,000 per.
This is Uppinangadi.
Uppinangadi bus stand. This is the this is where the
which is the other village of that sale deed?
Ilantila,
Both are different villages.
Uppinangadi, Ilantila village is the adjoining village to Uppinangadi and away from Uppinangadi bus stand, about more than one kilometer. Uppinangadi is on the national highway and close to that is close to Mangalore. One has to
What
pass.
is the basis for the land acquisition officer to fix 5,200?
That no records are,
Is the award here on record?
no.
Ma'am, you appear for them? Appearing for respondent, my lord. Which respondent? Respondent number 1, my lord. National Highway Authority of India, my lord. National Highway Authority. What are your instruction? Where is the land acquisition officer's award? My lord, I will take an instruction from my senior, my lord. Kindly accommodate a short date, my lord. Just say that as we find notice has been issued in MFA 1010 of 22. What is the similarity between these two appeals?
My lord, the same survey number,
Same
same owner,
notification,
same, my lord.
same village.
Yes, the same property, portion of the property. Here it is 45 square meters.
Sub notice for
Mr. Shobit Shetty generally appears
For- one, and you appear for? Respondent number Ma'am, you appear for three, no? 3, my lord. 1 and 2, just say the madam. The respondents 1 and 2 shall place before the court the award of the land, special land acquisition officer, including the English translation, if any, on the next date of hearing. In both the appeals. Just say, give it in June.
17/6. 19. To Mahesh Chaudhary.
This has been settled.
Yes, Your Lordship.
So what do you want?
Respondent, my lords. We have received the amount, my lords.
What
Matter
do you
will be
want?
disposed of.
The commercial appeal may be, the commercial petition before the commercial court may be disposed of in light because the commercial court, petition was filed seeking for the claim amount, which has already been paid to the
No,
respondent.
but what will happen to this appeal? Tell us that.
This appeal may be disposed of in light of this settlement, Your Lordship.
No, where is the settlement?
There's an affidavit filed, Your Lordship, on 18/1/2025.
Oh, this is that maintenance.
Yes, Your Lordship.
Now, you were to pay the maintenance to them.
Yes,
You have paid 86 lakhs or so.
yes, Your Lordship. I've attached the statement as well, at document number 2.
The counsel for the appellant has drawn our attention to the affidavit filed by the appellant. You
We
have the
acknowledge the
copy?
receipt. Yes, my lords.
Full stop, a copy, whereby para 6 reads as under.
Yes, Your Lordship.
The learner counsel for the respondent acknowledges the receipt of the affidavit and also the contents thereof. He states that an amount of 86,63,165. That's right?
Yes, Your Lordship.
Is it 165.20 or not 0.20?
86,63,165, Your Lordship.
165 has been received by the respondent. You have
Yes, my
received
lords.
it?
We have received, my lords.
Stop. If they say that in view of the affidavit, and the receipt of the money, the appeal be disposed of as settled. Okay, it's ordered accordingly.
20.
The commercial OS may be
My lords, will undertake to withdraw the same. The commercial OS which is pending in the commercial.
File an application based on
Please,
that.
madam.
What is there? You also withdraw that.
Yes, Lord.
Please. Correct.
Appeal for the appellant, your lordship, a short
For the
accommodation. may be-
respondent.
Short accommodation will be granted. We have prepared the list of events and synopsis. I shared the copy. Senior is having slight inconvenience today. Any short date may be granted.
2013 MOU and JDA. The respondents are the small agriculturists having only 1 acre 20 guntas, out of which 10 guntas have farmed road. So 1 acre has been given to the builder appellant for joint development 2013. So since 13 till 2018, so the litigation starts by filing a legal notice. So they have not fulfilled any of the JDA.
He's seeking an adjournment. What do you want? What do you say?
So matter is because 14/6/2024, this court has heard some time, and I have also filed counter appeal because the counterclaim has been allowed by the arbitrator. So therefore, kindly see the order sheet, my lord. Kindly see the order sheet. So on that day, this court has posted along with that matter, my matter 190 of second matter 190 of 2024. In the meantime, granted interim order not to put up construction. So we have, as per the order under section 33(1) of the Arbitration Act, the arbitrator has passed an order to cancel the JDA and subsequent GPA. So based on that, as cancelled, and subsequently we have already entered into a JDA into another one.
You have done it?
Yes, madam.
You have already given?
Already executed. So he has got the.
Is there any stay here?
Stay for not to put up constructions, madam.
Oh. So what is your, this thing, he's seeking an adjournment. Have you have any objection?
So kindly within 3-4 days, madam.
Not 3-4 days, we'll give a convenient date.
So Friday, madam, 14th. madam.
Not Friday, we will give you a date. Adjournment is sought on behalf of the counsel for the appellant on the ground that the senior arguing counsel is in personal difficulty. Just give it in April last week.
28/4.
Interim order may be extended.
28/4. It's a very long date, my lord, which it is very difficult, my lord, because the poor agriculture, they have no work at all, because they have depending upon this.
Give it around 15.
21/4.
Next.
This month.
Interim order may be extended.
Within,
Interim order, if any, to continue. No further adjournment.
Will not.
within this 1 week, my lord.
Not possible. Next interim order to continue.
Date.
Just give the date.
21/4.
4.
21/4. 21.
For the respondent.
Only 2 weeks time may be granted, my lord. Really, we have deposited this, we have completed this honorable court. orders,
What
my lord.
remains in this?
My lord,
Very short.
Yeah.
point, my lord.
Let's
LCR
see.
LCR to be Bandila, Swami, LCR Bandila.
No need for LCR. Come, what is the issue?
You see paragraph 23 of the judgment, my lords, page 46 of the appeal. DW1 admits my entire case. DW2 denies everything, including his own case. Their witnesses. Suit for recovery of money based on goods supplied. The defense taken is substandard goods were supplied.
My lord, 15 lakhs already complied, my lord. Actually, 16 lakhs something it was awarded. The trial court awarded, my lord. 15 lakhs we have deposited, my lord. On 2 weeks time may be granted for the arguments, my lord.
For what?
Senior is in station, my lord.
They are the request of counsel for the appellant adjourned to.
Kindly extend the interim order in this.
Interim order, if any, to continue.
Just a date to be fixed, my lord. It's a very short point on the last.
They give it in June, man.
5/6,
Next.
22. Gopal.
Commercial appeal, I'm finding this.
Yes.
Commercial appeal, my lordship, this. I think the money recovery suit has allowed below the court. I'm seeking.
What do you say?
This is the money recovery suit,
Yes.
and below court has decreed the suit, and I am the responding.
So you don't file your written statement, what will they do? Have you filed 9th?
That is the main aspect, my lordship.
Huh?
I'm suffering from some diseases, and continuously I'm filing this medical certificate also.
Where is the decree?
That's why I'm seeking the relief.
See, a commercial suit, there is no condonation of delay in filing written statement. 120 days, 120 days, no further time.
So I'm suffering from some diseases, so long time that.
Right, there is no condonation thereafter.
That's why I'm seeking
So how much is the liability?
the 11 lakh.
So you deposit complete amount.
Oh, my lordship, what happens there? I'm purchasing some cracker material. There is a lot of material in my ownership in the
So you deposit the complete amount.
my lordship. I'm purchasing almost 68,074. 68 lakh 74,000 of the material. They are not hand over my material to me. And also I'm completed entire amount, 61 lakhs is 2,000 to the plaintiff.
You deposit the complete amount. Okay. You deposit.
Lordship, what I'm saying that I'm already paid 61 lakh something.
You may have paid, but you don't file your written statement to say so. Why should we hear you now? We will hear you.
Continuously, I'm sick, continuously sick. That's why I'm not filing the written statement.
Very well. You want, is there any execution file?
Yes, man.
When is the date?
11th, tomorrow is the.
You deposit complete amount. See, you don't file written statement, nothing of that sort.
That's a COVID period ends, not filing.
That has not been believed
No, I'm
by the court.
I'm filing the legal certificate also,
It will not help you.
suffering from COVID and.
You are in a commercial
accident.
suit.
I'm suffering from COVID and accident all, hence I am not filing this.
Issue notice subject to the appellants depositing 75% of the decretal amount computed as of today with the Registrar General of this court. With the Registrar General of this court within 8 weeks. There shall be stay of the impugned judgment decree dated 11 September 2024 in COM OS number 74 of 2021. Where is the stay application?
%50 of the amount.
Just say that, just say, just before that, as notice, the learner counsel for the presses the stay application, then that order. On such of a nationalized bank, on such deposit, the amount we shall be invested in an interest-bearing FDR with periodical renewals of a nationalized bank till further notice.
50% maybe, 50% amount maybe.
75. Not in a case where you person doesn't file a written statement. You have invited the decree against you. Okay. Early hearing infructuous. Early hearing 1 of 25 has become infructuous.
19-6. 23 adjourned, 24 Shajesh Kumar.
We have filed the amended cost title. When did you file it? My lord, we filed it on 6/3, man. We have not seen it, Mr. Ajesh. It was not on record. Where is it? Just show us. What was the correction to be made? To include the name of one of the honorable arbitrators. There were 3 honorable arbitrators. Yes. So have you now included? Yes. All the 3 names, and we have described them as.
Lords, what has happened this morning is the other appeal, which was also listed on the last day, it came before the Chief Justice Court.
Oh.
And there a mention was made saying that this appeal is pending here. So the chief said he'll pass an administrative order. He's directed us to file a memo to that effect, the parties to file it.
So we'll defer it. Yeah, we will place it along with that.
Yes.
We'll place it along with
Yes,
it.
yes, it should be.
So it's only the cost title, my lord. So we will say nothing. Please, we'll do one thing, because that appeal is pending there. Yes. We will say this be listed before
With that.
along with that.
Grateful. Because there'll be an administrative order as to whether this will be before this court or that court. The court said it will decide whether it has to come before this court or that.
That was filed in 2025.
Right.
This was filed in 2024. Just say that we have been informed the connected appeal being, what is the number?
25 of 2025.
25 of?
2025. 25 of 2020.
25 of 25 was listed before court number 1. Stop. And a reference yes, sir, if that be so. And the counsel for the respondent has
I brought it to the notice of the court.
brought to the notice of the. We'll do one thing, just cut the last, say that, if that be so, subject to the orders of the Honorable the Chief Justice.
On the administrative side, that's what he said.
It's all right. So we are also saying that, subject to the orders of the Honorable the Chief Justice, list this appeal along with that.
Along with that.
Great.
Before the appropriate bench.
Precise.
We say that's all.
In this matter, my lords, I'm taking notice for R3, 4 and 5.
We are not taking anything.
Please.
We're just simply noting it. It will be listed along with that, subject to the orders before appropriate bench. Yes. Grateful.
Number 25. Party in person. 25.
This is regarding registration of FIR, my lord. Learned single judge, my lord, has
ಈ ಕೆಳಗಡೆ ಸಾಹೇಬ್ರು
ತಮ್ಗೆ ಒಂದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರಿ ಪೊಲೀಸರಿಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ರು. ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರು? ಯಾವಾಗ ಕೊಟ್ರಿ?
ಸಾಹೇಬ್ರು ಆದೇಶ ಆದ್ಮೇಲೆ ಅವ್ರು ಆದೇಶ ರಿಕ್ವೆಷನ್ ಕೊಡಿ ಅಂತ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ಮಾತ್ರನೇ ಹೇಳಿದ್ರು. ಬಟ್ ಇಲ್ಲಿ ಪ್ರಶ್ನೆ ಬಂದಿರೋದು ಸ್ವಾಮಿ, ನನ್ನ ಅನೆಕ್ಷರ್ಸ್ ಏನು ರಿಟ್ ಪಿಟಿಷನ್ 39/19 ಅನೆಕ್ಷರ್ಸ್ ಏನು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಅವು ಯಾವ ಅನೆಕ್ಷರ್ಸಿಗೂ ಅವ್ರು ಯಾವ ಥರದ್ದು ರಿಲೀಫ್ ನನಗೆ ಗ್ರಾಂಟ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಈಗ ನೀವು ಅಲ್ಲಿ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡ್ರಿ ಅಂತ ಹೋಗಿದ್ರಿ, ನಾನು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದೀನಿ, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನನಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಬೇಕು ಅಂತ ಬಂದಿದ್ರಿ ಇಲ್ಲಿ.
ಪ್ರೊಟೆಕ್ಷನ್ ಗೆ ಅಯ್ಯ ಮಾತ್ರ ನಾವು ಹಾಕೊಂಡು
ಅದಕ್ಕೆ ಕೆಳಗಡೆ ಕೊಟ್ಟು ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತಂದ್ರೆ, ತಾವು ಅಲ್ಲಿ ಒಂದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಬೇಕು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ಗೆ. ಅವರು ಆ ರೀತಿ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರೆ ಅವರು ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ಪ್ರೊಟೆಕ್ಷನ್.
ಮೇನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಪ್ರೊಟೆಕ್ಷನ್ ಬಗ್ಗೆ ಯಾವ ತರದ್ದು ಪ್ರೇಯರ್ ನಲ್ಲಿ ಏನಿಲ್ಲ ಮಾಸು. 39/19/2022 ರಿಟ್ ಪಿಟಿಷನ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 to register the FIR. Main petition, main writ petition ಒಳಗೆ main
ಪೊಲೀಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಾಯ್ತಲ್ಲ FIR.
ಇಲ್ಲ
ನೋಡಿ ಪ್ಯಾರಾ ನಂಬರ್ 3 of the order ನೋಡಿ. Lordships may kindly appreciate.
After the writ petition ಇಲ್ಲಿ ನಾವು ಫೈಲ್ ಮಾಡಿದೀವಿ ಮಾಸು, ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಸ್ಟೋನ್ ಫೆಲ್ಟಿಂಗ್ ನನ್ನ ಮನೆ ಮೇಲೆ ಮತ್ತೆ ಸ್ಟೋನ್ ಕಂಟಿನ್ಯೂಸ್ಲಿ ಆಯ್ತು.
FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ ಪೊಲೀಸರು ಅಂತ ಹೋಗಿದ್ರಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು ಅಂತ. ಈಗ ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ since the respondent police have registered FIR consequent to the complaint made by the petitioners ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ.
39/19 ರಿಟ್ ಪಿಟಿಷನ್ ಒಳಗೆ ಅನೆಕ್ಷರ್ಸ್ ಏನ್ ಮೆನ್ಷನ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, ಅವ್ ಯಾವ ಒಂದು ಅನೆಕ್ಷರ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಕಾಪಿಗೂ ಇವತ್ತಿನವರೆಗೂ FIR ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿಲ್ಲ.
ಈಗ ರಿಜಿಸ್ಟರ್
ಅದಕ್ಕೆ ಆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕಾಪೀಸಿಗೆ
FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಲ್ಲ,
ಆಫ್ಟರ್ ದ ಕಂಪ್ಲೇಂಟ್ಸ್ ಕಾಪೀಸಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ವೆನ್ ಯಾವಾಗ ನಾವು
Lordships kindly appreciate these complaints are all dated 2020 and 21. And my lord, FIR is registered in 2023. So my lord, subsequent to the complaint, FIR is registered. Though there is no.
What have you done on this representation?
Your lordship is not registered to main writ petition 39/19/2022. We are made it the 7 complaint and marked the annexures annexures N, annexures F. Is not registered the single FIR in the annexures, all the what are meeting in the writ petition mass.
The only contention is that, my lord, he is a journalist and his various issues have been raised by him. In view of that, my lord, there is a threat to him. That is what he intends to.
The learned single.
And on that record, my lord,
single
the learned
is not consider and not give the any
No.
relief.
No. On that record, my lord, the learned single judge
Met
has.
in the annexures in the writ petition 13/19/2022. Productions application is filed a year only, mine.
Annexure C may kindly be perused, my lord. That is one of the FIR which is registered, my lord. That is page 82, my lord.
It is not a FIR, your lordship. This is a.
It is a acknowledgement which is given, my lord.
This
There
is
where he says
made
that.
by only NC, your
that,
lordship. Page number. Not only this complaint, your lordship, I have made it the 7 complaints as my prayer, my writ petition prayer is very clear. We are made it the 7 complaints. complainants, why are you not taking action against them and why are you not registered the FIR against them? After the 7 complaints, when is coming the knock of the Justice Temple in this honorable court, alerting in the local police registered the second 2 FIR against the culprits. Still is ongoing the stone felting and assaulting on me. Prayer is in page 30, my lord.
Has he made a representation?
That I have to ascertain.
Ascertain whether,
Yes.
have you done?
No.
They say the request of counsel for the respondents adjourned to.
11-6.
Next.
26. Still number 26.
Pass over, my lords.
Awesome.
27.
For the appellant, lords. The appeal arises out of an order which relates to a lookout circular that was taken out by the appellant bank. There was a judgment of the Bombay High Court Division Bench which held that the power to issue a lookout circular was unconstitutional and not found. That's pending before the Honorable Supreme Court. So this appeal may await the outcome of the SLP.
Union has challenged it.
The union has filed.
There is a lot of law on this.
Yes, my lords, there is.
Now, what is the issue pending before the Supreme Court?
Whether the power exists with a public sector bank's managing director. We are a public sector bank.
That issue is pending.
Yes, my lords.
Now, what happened in this?
In this, we had taken out lookout circulars against the respondent. He owes about 2,800 crores of rupees to us and the connected matter Punjab National Bank. What the learned single judge does, my lords, is says that if the court thinks that the power does not exist, on a prima facie finding of unconstitutionality, granted the relief to the respondent and permitted them to leave the shores of the country. And there was no argument about unconstitutionality.
The lookout circular was kept in abeyance.
It was kept in abeyance without there being a challenge to the lookout circular.
You are for the bank.
I'm for the bank.
Mr.
Please.
You are for the union.
Please,
Yes.
my lord, the prayer in the writ petition, original writ petition was, my lord, to issue an appropriate writ directing the respondent to recall the LOC.
There was no challenge at all.
There's no challenge. The learned single judge says the LOC is non-est in law.
Yeah, without there being a challenge, without there being arguments by both sides,
Therefore, it is stayed, my lord, this matter is stayed by
because
the
notice has
court.
already been issued
Notice-
in my petition.
It's already
Stay
stayed.
also has been granted. Matter has to be heard finally.
Here's for the,
My lords, I'm appearing for respondent number 1, my lords.
oh, you appear. for
Please,
that.
my lords,
Yes, ma'am.
my lords, he is already left the country, my lords, on 13th of February 2024, my lords. Since the matter is pending before the Honorable Supreme Court, my lords, on the last date also, the matter was listed today because the matter was pending before, the last date of hearing was
When did he leave the country?
Immediately after the interim order in the single judge, in the final order in the before the single judge.
the impugned order was passed on 9th.
Overnight.
2024, my lords. No, he
No,
was-
no, it's not overnight.
It was not overnight.
It's
my
not-
lords.
it was
After
not overnight.
complying with the-
After
the
complaints of the,
9th and 14th, when did he leave?
13th of February. After complying with all the conditions passed by this honorable court. my lords. That affidavit
Case,
was-
although it has been stayed.
Yes,
the
ma'am.
effect is it should not be read in future cases.
Yes, my lords.
That's the only benefit.
Yes.
Then we'll await that.
please.
Yes, my lords.
We'll extend the interim order.
Yes, my lords.
It shows that.
The interim order need not be extended, my lords. It was heard at the admission stage and it was an absolute interim order in that sense. Your honors may kindly see the order of 18th April 2024 at the stage of admission. That was in my appeal. In the connected matter, there's no stay.
Pending consideration of the appeal.
Please, my lords.
Just say that we have been informed that an issue, the validity of LOC, validity of LOC.
LOC. The official memorandum granting the power to public sector banks to issue lookout circulars. There's a specific.
By the Ministry of Finance.
By the Bureau of Immigration, Minister of Home Affairs.
The validity of notification issued by the Bureau of Civil Aviation.
No, Bureau of
Bureau of
Immigration.
Immigration
by
and Ministry of
Ministry of Home Affairs.
Bureau of Immigration under the Ministry of Home Affairs.
Please, my lord.
Granting permission to the public sector banks to issue LOC.
Please.
He is pending consideration before the
Honorable.
Supreme Court.
SLP civil number.
Being SLP number so and so. The council states that the appropriate shall be to await the outcome of the SLP. Adjourn this appeal to give a date in June. Interim order. The order dated 18/4/2024 shall continue. Till the next date of hearing.
The similar issue came up before the Bombay High Court, my lord. Bombay High Court, the division bench of Bombay High Court was pleased to quash the OM itself that the bank does not have the.
Yeah, it need to be looked into.
Therefore, on that matter, appeal is filed.
We'll see, there is a lot of law on this.
Yes, my lords.
Lot of law.
Yes.
26/6.
Grateful.
Great.
Serial number 28. 28.
Appearing to the state, my lord.
Appeal for the appellant, my lord.
Yes. The writ appeal may not survive because pursuant to the learned single judge's order, the state has issued a fresh notification on 8/1/2025, my lord. Issue is appointment of special public prosecutors with POXO-related cases as per section 32 of the POXO Act. Now, they only will look into the POXO-related cases and nothing else. So the earlier notification, which was under challenge before the learned single judge, the notification made public prosecutors to also look into POXO cases. So they were made to have a dual role to play. So that was set aside. But pursuant to that order, within 3 weeks, my lord, the learned single judges, within 3 months, sorry. So we have passed a notification on 8/1/2025. Saying, now public prosecutor for POXO, Yes. especially for Special- POXO. Especially for POXO as per the Act and the Supreme Court decision. So
what remains now in this?
This writ appeal would not survive is my humble submission.
My lords, I pray for in 1 week of time, we'll file the additional documents.
So
So,
what was your case?
my lords, and I'm new to here.
See, 29 is clear, but no, only thing, if you see paragraph 29, Please, my lord.
Till such appointments are made, the persons who are working as special public prosecutors in special course of contract shall continue to function. Now, after you have issued 8/1/25,
There has
have you made
been,
appointments?
we had made appointments. My lord, what has happened is they have challenged that notification, and that notification, there is a stay before this honorable.
Oh, okay.
So there's a,
So there is a stay there.
yes.
From
affecting that.
Yes.
But today, in any case, what remains in this appeal?
This appeal would not survive because of the current notification in place and that being stayed. So, because over here, the prayer sought for is that the earlier notification be given effect to, which would not.
What does the earlier notification say?
The earlier notification was the public prosecutors who are already there in various districts. They become special public prosecutors as per the POCSO Act. But that was set aside by the learned single judge, saying it's not in consonance with the Act and the Supreme Court ruling, which, yes, which says only POCSO related cases, the special public exclusivity. So then we issued the subsequent notification, which said only POCSO related cases, the special public prosecutors would be.
My lord, I'll seek instructions from my senior. Can you adjourn this matter for a week?
We'll pass over, get your instruction.
My lord, a week's time, my lord. I mean, our senior is out of station.
The request of counsel for the applicant, give it next week.
17-3.
29. Keshav Dapa.
My lord, this is with regard to the BBMP's appeal, my lords. With regard to the repeal and savings clause that the learned single judge had failed to take note of. These were acts that were done in terms of the previous provision, my lords. Yeah, what is? All acts are, you know, what you call are saved. Are saved, my lords, in terms of the previous act or regulations that were existing. For repeal and saving. Please, my lords. But that was not taken into consideration in the notifications, the show cause notices that were issued by the BBMP was set aside, giving us liberty to issue fresh. Notice has been issued, delay had to be condoned. Even appearing for the respondent. There is no appearance for the respondents despite service. The delay of 62 days and 94 days in filing the appeal. You appear in both the matters? My lords, there are two different counsels for both the matters. I appear in both the matters. For the appellants, you appear, no? Please, my lords. The reason stated in the affidavit in support of this. Delay of 62 and 94 days. List the appeals for hearing. My lords, if a short date could be considered, my lord, because it's a short point of consideration. I have judgments also of the Karnataka General Clauses Act, which mandates in terms of the BBMP Act. If your lordships could take 376 minutes. The first proviso, Section 6 of the Karnataka General Clauses Act of 1899 would apply. Was the notice issued on the earlier act was at a time when the new act was already in place? My lords, it was in place, but we could not have issued it in terms of the new act because the financial years that we were seeking for the property tax to be paid was for the years that the new act was not in place at that point of time. So therefore, we had to issue it even though it is after the my lords. Would you invoke the old act when it has been repealed? My lords, it is not about the invocation of the old act. The only thing is the actions were in terms of the old act because the financial years could have issued under the new act. My lord, we could not have. More relatable to the old act period.
We could not have issued it under the new act because it,
We could have invoked the old act when it was sans repealed.
my lord, because it was for the tax that were due. My lord, if I make just clarify, my lord,
And because what you say is because the period relatable to that,
to that and the considering that
tell
the
us one thing,
my lord,
all those, you know, relatable issues to the, under the old act are not saved under the new, under the new act.
they are saved, my lord.
So if you say, okay, can't you issue under the new act, being saved?
My lords, now if BBMP were to issue under the new act, they could not have issued it for those financial years because
Right.
now
Anything done, sought to be done under the old act.
because
saved.
anything done or sought to be done are saved, my lords. But the question that would arise is now, if I do it in terms of the new act, I did not do it, then how can I invoke the new act?
The judgment on this.
I have, my lords, a division bench of this court's judgment on sections.
This held under the old act,
My lord, not insofar as this act is concerned.
required consideration.
Please, my lord.
Appearing
Here for who?
respondent, my lord.
The respondent. In which matter, what is your name?
C. Shankar Reddy, advocate.
So you are in 29.
Yes,
29.
There is 29.1 also which arises the same issue.
The same issue, my lord, both two different judgments, two different facts might be here and there a little different, but the consideration is the same.
You. Fresh proceeding will not be initiated under the old act have come, I pass the following letter. Was bearing this. Liberty is reserved. So what is the difficulty? See, in terms of this liberty, are you not within your rights to initiate? You go for that period.
Well, I do have the right to initiate is there, my lords, but this was an act that was done by the BBMP.
But how are you? You can take the protection of the order. Because liberty has been granted by the court. You will initiate.
Or I'll seek instructions on that. But my instructions were very limited to for this purposes, my lords.
In terms of BBMP. If you like to look into this,
My lords.
that liberty granted means something permission granted to you, even for old transactions, you can take under the new act.
My lord, with that observation, I have
You can last liberty.
liberty is reserved to the respondent corporation to initiate fresh proceedings in terms of the BBMP Act. But the problem is, my lords, when these notices were issued, the BBMP Act had a restriction of 5 years before, up to which I could have initiated the property tax. At the time when the previous act was in force, I could have gone a little further ahead. So that issue will come and my hands will be tied at that point in time. Because here the assessments that were done were of even 16, 17, 18, 19.
Equivalent in, none for the respondent in 689 of 24. Just say that Mr. C. Shankar Reddy is appears for the respondent in 48224. They counsel for the parties to file the written submissions. Along with the judgment, they want to rely within 4 weeks. This the appeals for hearing.
My lords, I've also sought an IA for additional documents.
What are those documents?
My lords, those are documents with regard to how the proceedings were initiated, my lords. for property tax to be adjudicated by the BBM.
What do you say on additional documents? I want to take instruction from my senior man. Instructions, Yes. just say the appeal and the connected application be listed on. List here for additional documents and the appeal. In the appeals.
19.6.
And if a shorter date could be accommodated, Manoj,
So possible.
grateful. Manoj.
Number 30, adjourn.
Manoj, IA for continuation of delay. Manoj.
That we have allowed.
Grateful.
We allow the delay application. We allow the delay.
30, adjourn. 31. Shechappa.
Short issue that arises in this writ petition is, my lords.
Challenge.
The challenge is, my lords,
But what do you say on the tribunal's order? Why settle?
my lords, in this particular case, at the time of issuing the notification, my lords, the issue of stammering being a disqualification for a loco pilot, assistant loco pilot, not connected with the public was never a issue, my lords.
It's not relevant. We'll say why.
Please.
It's ultimately for the concerned authority or the department or the respondent to consider whether this particular, you won't say disability, difficulty would be conducive for the job in question.
This difficulty was never a difficulty for this particular post at all, is my humble submission.
Whose outlook would be?
My lords,
It would be whose outlook?
it would, my lords, if a condition is not imposed at all, then the authorities could not thereafter come back and say this is a disability or a
Expect everything can be put it in black and white. It is the medical board which will see
my lords,
whether this particular kind of a difficulty
my lords.
or in a case, given case can be a disability would be conducive for the purpose of this discharging duties on this post. And mind it, we are dealing with an issue of an appointment of a loco pilot. Loco pilot is what? Who drives the engine or who is the
Who is assisting the pilot, my lords, assistant loco
the driver?
driver.
And you need to be in communication with both the guard and even the concerned railway station also.
Please, my lords.
So to that extent, possibly, this can come in the way.
My lords, I would submit this way, my lords. During the hearing of this particular petition, my lords, the board's decisions was looked into. The assessment made by the specialist, the speech therapist, was looked into, and thereafter this honorable court had directed the Institute of Mysore Speech and Speech Therapy to produce a report denoting whether this particular deficiency would come as a deficiency at all. The report is before this honorable court along with the memo, my lords. I would request.
Who has given this direction?
This honorable court, my lords. This honorable court, by its order dated
There is already a medical opinion
my lords,
of the respondents.
please, my lords.
That it will affect the working.
My lords, all through the medical opinion specifically said it will not affect this thing, my lords. The doctors who have analyzed this particular,
all the reports, my lords, for a minute.
Show us their record, this thing, the medical examination carried out by the
My
respondent.
lords, if my lords would take the memos filed before this honorable court itself, my lords, for a minute. Memo filed by the respondents on 10/6/2024. Ten 6/2024.
This is from Mysore.
Mysore, my lords. That is because there's an order from this honorable court to the Mysore Institute.
Does the Mysore knows what are the
Yes.
functionings?
Yes, my lords. In the memo of the respondent itself, which is dated 10/6/2024, page number 1, my lords, annexure R1. Your Honor, has it, my lords?
Which page?
Page 1 of the document, my lords, annexure R1. This is how it looks, my lords.
I have annexure R1 here.
My lords, along with the memo, they have produced, my lords. My lords. Page 1, my lords. There is a reference from the Director, All India Institute of Speech and Hearing, Mysore, to the Director. With reference to the above, Sri Rishi Kumar, roll number so-and-so, candidate for appointment for the post of ALP, technical in A1, AB, medical category, has been directed to your institute as per the instructions of the Honorable Court, High Court, Bangalore, in WP number so-and-so. Honorable High Court, Bangalore, has passed the orders as under. After substantial hearing to a speech query, specific query posed by this court to the learned standing counsel for the railways, whether the petitioner would be A for the post of 1 assistant loco pilot, ALP, AE1, and technical grade 2 sign and technical communication department. Learned standing counsel for the railway submits that the consideration of the writ petition, if a direction is issued to the railways to have fresh medical examination, the same shall be undertaken. In the light of the above, we direct that the petitioner shall be referred to All India Institute of Speech and Hearing, Mysore, for fresh examination by giving the specific details or duties of the and responsibilities of both the post and seeking a specific opinion whether the petitioner would be medically fit for the appointment to either or both the post. The institute shall be at liberty to conduct scientific medical examination if required. He has to be examined duly considering the court order. Accordingly, the nature of duties and responsibilities for assistant loco pilot, ALP, and technical grade 3 signal and telecommunication department has been enclosed in annexure A and B. Next para is the conclusion para, my lords. The next para at page 3, my lords. Though this report is not a full, clear report, your honors would see provisional diagnosis, clinically fluent speech. Mr. Rishi Kumar was reevaluated on 12/1/2024 using the standard stuttering severity instrument SS1 and SSI-4. Based upon his performance in the clinical setup, he was diagnosed as having clinical fluent speech. He is using prolonged speech with slow rate, which has enabled him to improve the fluency. Owing to the duties and responsibilities, this is important, my lords. Owing to the duties and responsibilities of the technicians in S&T department and assistant pilot in electrical department mentioned in Y so-and-so, dated 9/1/2024 and number so-and-so, dated 11/1/2024, Mr. Rishi Kumar will not have any difficulty to carry out any physical related work. He may be able to carry out the works related to the communication as he is following strategic and could speak fluently in the clinical setup. This is what the report is, my lords. And if your honors would turn to the further memo that I have produced, my lords, because that memo did not have a very clear denotion of all the aspects. RTA was filed by the petitioner to the medical institute to provide him with the medical report, my lords. Your Honor would see at annexure D of the petitioner's memo dated 18/6/2024. At page 3, my lords, Rishi Kumar, so and so, frequency, job task 3, reading task 2, duration 2, physical concomitation, distractions, sound 0, facial grooming 0, head movement 0, movement of extremities 0, total score 7, percentile below 10, severity, no disfluency. Thereafter, it says speech naturalizing rating towards natural sounding speech, provisional diagnosis, clinical fluent speech.
Why there is a difference between their medical examination and this?
My lords, they go on this percentile, which is not at all a parameter, my lords, saying that if it is nowhere in the IRMM, which is the Indian medical manual, my lords, they do not categorize any percentile to say how much should be the disfluency. Below percentile is never prescribed. They say it is below so and so, so very arbitrarily they do not take this petitioner into this thing.
It's better known what are the service conditions, what are the functioning.
My lords,
And the railways.
Correct, my lords. Now I am before this honorable court only on this particular aspect, my lords. If at all, if the medical reports were to say that he is fit and the the railways do not get him into employment, my lords, the only option left before me is to approach the.
It has to be seen in a perspective now.
My lords,
Whose fault would it be? Will it be railways or by the court?
My lords, if it is arbitrary and not in the lines of the parameters set down, my lords.
The parameters for arbitrariness has to be seen from the perspective of the railways. They are the employer.
Correct, my lords.
And see, you are doing something, where the lives of others are also dependent on you.
I bow down to that, my lord. The aspect of the Supreme Court laying down the aspect of whether disabilities other than what is provided under the Disablement Act can actually create the employers can create another class by itself. And if so, would it not become arbitrary, my lords? That's
disability.
My lords.
It means anything above 40%.
Correct, my lords. Now
is it a case of above 40%?
It's not the case of above 40%, my lords. And if that is the case, my lords, they say it's a disability. And if that is a disability, they'll have to specifically denote. I will take your honors through that, my lords.
And not a disability as is recognized under the
Disabilities Act. Now, the Supreme Court said, my lords, by not following that particular aspect of saying, bringing in another class altogether under the very aspect of the discretion of the authorities in whatever manner would create a separate class by itself under the disabilities, this thing, my lords. That's one. I see that, my lords. And the other aspect which I've placed before this honorable court is a decision of the Central Administrative Tribunal, Hyderabad, my lords.
You can only best argue this is this difficulty.
Please.
Disability. Difficulty would not affect the functioning.
That's
the best you can. But who would assess that? Surely not our discretion or not our work. We have to relegate it to the authorities concerned. Who are the authorities? The
medical board. Now there is a very specific finding of the Indian Institute of Speech and Therapy from Mysore saying that this disability is not there.
Let's assume for a moment the appointment was in army.
Please, my lords.
Can we say you go to with the same difficulty, you go to this institute at Mysuru and you assess it. Okay. And they give a report. Can we say, and contrary to what the army is saying, look here, with this kind of a difficulty, we can't allow him because the functioning requires a normal person without this kind of a difficulty, and we can't take it. Can we Today we are concerned with railways. Can we say, no, you still take it because the institute in Mysore has given a recommendation like this?
My lords, I just oppose this particular aspect in a position where if a particular person were to have a disfluency or stammering would be a condition which can come in at any point in time to any person, my lords, and can disappear at any point in time to any person. Now,
best example in Mr. Nani Palkiwala.
please, my lords. Now the issue. The issue is, my lords, now if at all, if this person were to be appointed and he did not have this disfluency at that particular point, my lords, and subsequently the board found or the respondent found that he developed this particular stammering at a later point in time, there is discretion for them to put him in any other this thing, my lords. I would then, then I would call upon this court to at least place me in that light, my lords. Now, for example, in this particular case, my deficiency does not come in the way is established by the reports of their own medical doctors, my lords. And if this deficiency were not to be there at that particular point in time, which was also not a condition under the employment invitations that were given at that point in time, my lords, I go and participate. They find that even the parameters are not there to a particular percentage to say that below this should be considered as stammering or above this should be considered as stammering or a disqualification. That parameter is nowhere available. Then it leads to a situation of discretion at the foot of the Lord Chancellor, my lords. Then the aspect of what petitioner is facing is what is to be faced. Under those circumstances, my lords, if this issue were to come up after he being appointed, were to be placed before this, just opposed in that particular situation, my lords.
Once you got an appointment,
My lords.
you can't be terminated, arbitrarily. That's a different issue. But we are at this stage of getting in.
Even at this stage, my humble submission would be, my lords, it cannot be arbitrary, my lords. They cannot go contrary to the reports.
What is arbitrariness? Tell us.
Arbitrariness is where the reports, one, if a condition is not specifically denoted, my lords, and second, if the parameters are not specifically denoted and they are given their own wins and chances in so far as determining whether a percentage of below 3% is
But why will they deny you? What wrong they have? What wrong or what a sort of a malafide they have against you? Nothing of that sort. That is not your case also.
My lords have not.
And you are not putting your case at that level.
I'm not putting the case at that level, my lords.
So, something like that. He said this is the deficiency or this is the difficulty. In the given situation, because ultimately you have to drive a train.
Please, my lords.
So in that situation, and it requires, conversation with the guard, maybe with the concerned station which you are passing through. All those things requires that we should not have this kind of a difficulty. That's basically their issue. And who will look? It's the railways which has to see.
My lords, the issue is,
That's
my lords,
the intent of the tribunal's order.
that is what the tribunal looks at, my lords, to say that if board has decided in a particular manner, we will not interfere. But the issue is, my lords, the board has not considered the manner it's supposed to have considered, is my humble submission, my lords, because that very aspect, the railways board, which
you want us, we can send you back. Which board, we will change the board. See, and mind it, the board consisting of all the specialists, they have formed an opinion. Unless and until there is something wrong, which you allege something wrong, who are the board or the process which they have evolved or followed, it was contrary to any statutory rules, we are with you. Is it such a case you have to set up?
the case that I've set up is, my lords, this very aspect of the disfluency is never a consideration at all, my lords, for people not within the public contact, my lords. That is the word used in the rules and regulations followed by the
Nothing wrong in the manner in which they have assessed you. There's nothing wrong in that.
No, my lords, there is wrong in that, my lords, because the parameters also is, my lords, parameters are this, my lords.
We'll come back after.
Please, my lords.
May I request, in this matter, I'm appearing, my lord, in this matter, after the matter coming up, I'm sorry, I'm excused. After matter coming up, the Honorable Court had directed us to file an affidavit. Today, I don't have that affidavit. If your lordship may have it tomorrow, my lord, I'll address that, my lord.
My lord.
We'll have it too.
Please.
One submission, my lord.
Mr.
Serial number 34.
Who states he appears for the respondents, we notify. And the registry may be directed to show my name, my lord. My name is not shown in the past. Registry shall show the name of Mr. Bhushan. In Please. case of Mr. Along with, my lord, along with. With Mr. Nishant Punni. Please.
My lord, serial number 30. Serial number 34. my lord.
34, what has to be done?
There is some inconvenience
the arguing counsel, my lord.
Who is the other side?
I informed the other side of.
Who appears for the other side?
I appear for the respondent.
This is the respondent corporation is a government agency.
Yes.
Appellant is the government.
Just have it adjourned.
My lords, 33, my lords, serial number
Back after
30.
lunch.
And apply.
for your application.
My lords. Senior is not well from 3 days, my lords, please.
The Q3 is a batch of petitions.
Please, my lord, I informed all.
He fixed the date, my lord, for today. In between, my lord, I moved an application on that date also, my lord, today's date was fixed.
What is the difficulty?
He is not well, my lords. He is not well from 3 days. 1 week, my.
They're all at the verge of retirement, my lords. They're all at the verge of retirement.
In their age?
Almost, my lords, now 59, 50.
The 4 people already, my lord, they got retired. They attained the age of 60 years. The university relieved them. This is a case where, my lord, they are working, my lord, from more than 20 years. Continuously.
They are having academic functions.
Academic, well, they are teachers.
The administration.
Teaching.
They are,
Yes,
my lord, the lecturers, having all the qualification for becoming a lecturer, and further, my lord, they have been discharging the duties on par with the other
Today they are
lecturers.
working.
They are
Please, my
working.
lord.
My lords,
How much-
if
how
I may
much
be
they are being
permitted, my
paid?
lords.
Okay.
20.
As on earlier, my lord, they were being paid 10,000, 12,000, it was increased. As on today, my lord, 28,000 is being paid. My lord, in similar situation, Dishonorable Court, Division Bench of Dishonorable Court, my lord, in University of, my lord, Veterinary and Sciences, directed regularization. In fact, my lord, a contempt petition was filed. Contempt petition was dismissed, and in the Honorable Apex Court, my lord, before the Honorable Apex Court, in the contempt petition, considering the case of their continuous length of service, my lord, a direction was issued to regularize their cases. And also, my lord, in recent.
Yes.
My lords, if I may be permitted, my lords. In some of the colleges, these lecturers, they are doing everything. They are the principals, they are the attenders, they are the teachers and everything. Single-handedly, they are doing everything. There's no single faculty who's a full-timer, my lords. And some of them, they've already retired also, my lords. They've been fighting for over 15 years now. And the university is hell-bent upon not to regularize them, my lords. And the said university is a very prestigious university, my lord. But what has happened is, most of the, I think more than 80% of the faculty are all guest faculties, my lord.
Since
For ages, they have not done the recruitment, my lord.
Since 2007, my lord, there is no recruitment. And in 2007, my lord, one batch of, my lord, similarly situated persons approached this Honorable Court, my lord, in the year 2003. As per the order of the division bench in 2005, 2007, my lord, a scheme was framed. They were regularized. We did not, my lord, fit within because, my lord, we were not the petitioners as on that date. Then, my lord, Uma Devi case came, my lord. Thereafter, my lord, they slowed down all the processes. However, we were continued, my lord, till 2016. Then we filed the writ petition. Similarly situated persons are already, and my lord, the honorable learned single judge.
For the appellants. List on, give it second week of April.
Lords, can it be any short date, my lord?
My lord, my client from last 25 years continuously working. They are selected by a selecting committee, my lord, and I process a doctorate, your lordship. And they have got a too short a term, your lordship. Your lordship may kindly give a short date, your lordship.
My lords, it may be said as finally, my lords, let there not be further adjournments. They shouldn't take any further adjournments. That's it, my lord.
If I can request your lordship, 22nd is a working day for Saturday.
22nd?
Is a working.
No. Next.
Lord, interim order may kindly be extended, my lord.
Interim order, if any, to continue.
Please.
Serial number 32, Mahesh.
I appear for the petitioner, my lord.
Yes, so the respondent.
Yes.
My lord, the petitioner before my lord is aggrieved by the communication impugned order. My lord, under 1802A of Railway Board Volume 2, my lord, I have been in the public interest, retired public, compulsorily, kind of early premature retirement. I'm not disputing that, my lord, I did not even challenge, though I did make an attempt to find out exactly what is the reason behind forcing me to go out prematurely, was not answered at all. However, my lord, I was not aggrieved by it. Then I made an application to render me the consequential benefits like gratuity. Instead of extending gratuity, they say issue annexure A4, my lord, page 84, where they simply say that since there is FIR filed against you, case is pending, we will not release it. That is not permissible, is the only limited case of the petition.
What is the FIR about?
My lord, FIR is about, they claim that I allegedly made an attempt to demand bribe based on reliable information, what they say. Under the rules, gratuity can be withheld only in case if I am held guilty in any judicial proceedings or departmental proceedings. Mere pendency of a criminal case or filing of an FIR do not.
What do you say, Mr. Bhushan?
But if your lordship may kindly see 71, page 71, annexure A2. In the petition 100919009. Your lordship was pleased to ask, what is the FIR with regard judgment?
But there is one thing,
Please, my lord.
only the moral turpitude. He is only then,
If that is the
turpitude or at the most, loss to the employer, at the most.
perfectly right, my lord. If there is no loss to the employer, I am, my lord, I can understand what is falling from the court. If there is no loss cost to the employer, that I should not withhold his waters. That is first point. If your lordship may kindly see, Lord, in this case, as on the date of his retirement, a criminal case was pending. The criminal case,
By CCS pension rules.
Yes.
Railway board has.
Railway board separate,
Mutandis verbatim the same. my lord.
same.
So,
Of course, my lord, I'm sorry, my lord. But the fact was that even though the charge sheet was filed, I know my learned friend would say cognizance was not taken. Cognizance taking is an act of the court, my lord. But the charge sheet was filed.
what difference it would make? Let's assume for a moment, even charge sheet has been filed, charges framed. Let's assume to go that extent. The trial has not committed, it has not been decided.
Lord, two things in these two matters, two things are there, my lord. The first thing is that, my lord, if he is made compulsorily retirable, then the department proceedings would not come in the way because he's retired. The second thing is that, my lord, with regard to the pension, both the matters are with the same.
Now, what is the penalty imposed in the departmental inquiry?
It is yet to be initiated. my lord.
Is it
Not.
To be initiated.
Yes, they have not done it. The moment I challenge this in the tribunal, my lord,
He will be entitled to provisional pension.
He is getting it.
Now gratuity. Now show us this. Oh, very good. Let's show where are your pension rules?
That is,
Where are your retirement rules? He has attained the age of the superannuation.
no, my lord, I was prematurely retired. I have 6 months to retire. I would be retiring in October 2020.
Prematurely retirement means?
It's a kind of compulsory retirement when, my lord, pending of an FIR, at the most empower them to assess my credibility, whether I'm a desirable candidate.
Is under like akin to 56J.
Exactly, ma'am.
So that is, it's a compulsory retirement.
Kind of compulsory retirement.
Compulsory retirement, you have retired.
Please,
How many years you have put in?
33 years of service.
Yes.
30 plus.
Years. Then, Mr. Bhushan, so he's getting, this thing. For provisional pension. Where is, under what authority you can stop gratuity? Only, today we are only concerned with gratuity.
Please, ma'am.
Under what authority?
for that, my lord,
Is he paid under Payment of Gratuity Act? Or under the pension rules?
Under the pension, rule, they quote 10(1)(c).
Show us the pension rules.
Please, my lord. They quote 10(1)(c). Impugned endorsement, talk about 10(1)(c), my lord. Page 59, we have extracted that, ma'am.
it's there in the order also.
Order also. Page 59,
See the order, which page, which para?
page 59, my lord.
No, in my lord, in 19009, it is page 45. Rule 10, please, my lord. C, provisional pension where departmental or judicial proceedings may be pending. Rule C, my lord, may I read it?
See, then the gratuity can be stopped. Page.
Page 45, my lord.
So the ministry, the pagination doesn't match Mr. Bhushan.
Please, no, my lord, this is the petition. I'm sorry. In page, that is in page 9 of the,
Three.
please, my lord, 19009, my lord. Please, in page 9 of the order, man.
In
Please.
respect of railway records, accounts officer shall authorize provision where not exceeding. Pension shall be authorized by the accounts officer. No gratuity shall be paid until the conclusion of required duration.
True, my lord. That is what wrongly misleading provision has been cited by the department.
Which
Now,
is
my
what?
lord, in order to apply 10, my lord, kindly see 9, previous page, page 44, my lord. 9 sub rule 5. It clearly qualifies when 10 can be applied. For the purposes of this rule, may I read it, my lords? A, departmental proceedings. I will skip to B, my lord. Judicial proceedings shall be deemed to be instituted in the case of a criminal proceedings on the date on which the
State take cognizance only when the charges are same.
Yes. My case is only that.
But let's see the other provision.
If your lordship, in the case of,
That shall be paid. But that judicial proceedings have been interpreted or been defined to mean only when cognizance is taken. In the case of criminal case.
that is the reason, my lord, I myself brought it to your lordship's notice. That if your lordship may kindly turn to last paragraph of the page 53 of the judgment in page 17.
What does it say?
In the present case, FIR was filed by CBI against the applicant on 28/4/2018. The charge sheet was filed on 29/6/2019. Cognizance has been taken by the jurisdictional court on 10/6/2022.
What happened on 2022?
10,
Do the tribunal say this is a cognizance? Cognizance has to be understood in law.
the
In law is what? Charges framed,
charges frame, charge sheet filed,
sheet file, then arguments on charge, then charges framed, then cognizance. So this cognizance, I don't know, what is the relevance of this day? What is the relevance of this 10/6/22?
My lord, I was compulsorily retired on 12/12/2019, my lord. They say charge sheet was filed couple of days prior to his retirement. That should be the date for consideration. But rule says the report of which complaint or report of which cognizance is taken. So that date becomes irrelevant. What becomes irrelevant is date of cognizance. Admittedly, for 3 years, there was no cognizance, my lord. They cannot deny me my benefits.
It's not the question of denying, my lord. For a moment, if your lordship may kindly turn to page
What is the
207.
gratuity payable?
I'm sorry, my lord.
How much is the gratuity payable?
Gratuity is 20 lakhs.
For a moment, my lord.
20
No
lakhs rupees.
hardship would cost to to the petitioner. For a moment, if your lordship may kindly turn to page 207. The certificate of the Southeast Central Railways with regard to the Provident Fund of amount is paid.
Provident fund is payable,
Paid.
there is no lien.
Central government employees group insurance scheme is paid.
My money.
Commuted value of pension is
You may pay 100 but deny one. He has come for that one. You may pay 100. He has come for that one. So that's where we stand. You tell us cognizance means this filing of charge sheet.
it's not that. To be honest, no, it's not so.
Till date, the charges have not been framed.
No, my lord.
Charge sheet was page 208. A memo is produced by the applicant before the
Any judgment in your paper, any judgment?
My lord, this honorable court recently, my lord, on November 2016, appeal has sent the same. Referring to KD regulations, which is a copy, are you not clearly held, my lord, that cognizance is the crucial thing that to be taken, or else you have to release the benefit that has been done.
What mean by cognizance? What does the court say on cognizance?
On cognizance, my lord, they say mere filing of FIR is not relevant. Cognizance should be taken. That date is crucial.
What is cognizance?
Cognizance is when the report filed by the prosecution is taken note of by the magistrate therein. And that is the only relevant fact.
The charge sheet is filed.
Please, my lord.
The summons goes to the accused. Or is it in his presence?
This is a special court, my lord. I've already given last time. Last but one page, my lord, paragraph 14. Refer to 172, my lord, which is similar, exactly verbatim, same to this regulations. Last but one para is relevant, my lord. It is relevant to note that the endorsement withholding the pension came to be passed on 28/6/22, as cognizance was taken only on 6/8/22 in terms of the explanation to Regulation 172. As on the date of endorsement, there was no judicial proceeding that was pending. Therefore, my lord, exactly the
No,
case.
may I read the previous para of that? If your lordship may kindly come to page 11. In page 11, the facts are entirely different. Page para number 13, my lord. The question is, the question in the present case is also whether the judicial proceedings as contemplated under Regulation 117 have been instituted for the purpose of Regulation 172. The word institute would refer to the commencement of the certain proceedings.
See, here the requirement is different. You see page 8,
Page 8,
the judgment.
please.
See, in the case of means on the date on which complaint
Please.
or report of police office
Yes.
of which magistrate take cognizance is made.
The same 95B6 talks the same, my lord.
Let's see. Your question.
95B, my lord. My lord, page 44. Or 45, first line of 45, my lord.
In case, on the date on which complaint or report of a police officer of which magistrate.
Exactly the same, my lords, verbatim. And this point is admitted by them. They do not dispute it.
The judgment quoted by my learned friend may not be applicable to this case.
No, that is applicable to the extent to
Yeah.
show what is institute. The first they have to demonstrate they have instituted a case against me, which is then pending. Mere FIR do not qualify to say it is instituted already.
May I draw your lordship's attention to the objection, which is already there.
The cognizance was already taken. No?
One 173 is filing the report.
Please.
This was a state case, no? This was by CBI.
Yes.
How does he act on the charges, charge sheet filed?
One 193 maybe.
Here, please, 193. The Lord's kindly,
193 mil.
90.
No, my lord, a cognizance of offense by Court of Sessions. Lord, this is Court of Sessions. Therefore, it is 193.
This rule says magistrate, the rule says sessions. So it is used in the context of whosoever has to take on.
Please.
After this report has been filed, what further action the magistrate has taken?
Not the very report contained a lot of objections. It was returned often. Then finally they complied with the objection. That is only in 2022 it was taken on record. Thereafter, no action taken so far, my lord. It is still in the same stage.
It's there in page, my lord.
The impugned order, my lord, was issued on 5th January 2021, saying at that time, it is not, they don't even have the
For a moment.
argument to say cognizance was taken because it was in January 21. It was not even just a month thereafter, after my premature retirement.
If your lordship may kindly turn to page 210.
And being not happy with that punishment alone, my lord, curtailing my service, now they want to initiate inquiry also on the very same charge for which I have been compulsorily retired. The railway board do not say 1802 if application of 1802 will curtail my benefits. No, it says it is not as a measure of penalty, you will be entitled to every benefit. They choose to impose me that punishment, but they're not ready to give me the benefits arising out of. And they want to have inquiry also, my lord, on that, which is the connected matter. Charge sheet. This honorable court, my lord, in that judgment has exactly answered the position which is now being
Deal with cognizance, it deal with institution.
True, my lord. That's my case also precisely. 9(5)(b) says when it shall be deemed to have been instituted, a criminal proceeding against a person, unless they establish that it is an institute.
Say take cognizance.
Cognizance,
What do you mean by cognizance? It is to be decided is when does he take cognizance?
cognizance.
And on this day, he take cognizance means on that day it has been instituted, judicial proceeding is instituted.
Yes, my lord.
That's
So
how it has to be.
the crucial date is when, according to them, June 2022.
190, section 190 of CRPC, upon
Report or a complaint,
police report on such facts.
please.
So the filing of charge sheet is sufficient to say cognizance taken, which amounts to institution of judicial proceeding.
Even in that case, my lord, my case, 12/12/2019, I was retired. On that day, no cognizance, no charge sheet.
Charge sheet.
No, my lord, that is my case. Charge sheet came after 3 years. They cannot deny me my 20 lakh rupees, and also you want to initiate inquiry.
That, Mr.
For a moment, if your lordship may kindly turn to page 210.
Mr. Bush, charge sheet was filed on the date of retirement.
No. They were admitted in the reply.
There is the cognizance. Forget, these are all academic then.
What is there on record, my lord?
No, you're right.
But the fact is that, my lord, in this case, what my learned friend, that is a case where somebody else had filed a complaint against him, though, therefore the court.
It's a private complaint.
Private complaint.
CRP.
Please, my lord. Insofar as.
But it is a state case here.
Please, insofar as this state case is concerned, your lordship, in the matter of S. Ramo, in the division bench of Delhi High Court, as well the charge sheet, the charge memorandum could not be quashed by the, because that is in the next matter. In the next matter, he sought for quashing of that.
No, that in any case, that can be seen.
Please, if that is pending, if the charges are pending, automatically this will have to be there, my lord.
When was the charge sheet issued in the Department of Proceeding? No charge sheet has been issued. He has been compulsorily retired, huh?
Yes, ma'am.
Without inquiry.
Yes.
So
Madam.
that is.
Madam. I have only one copy, my lord. I'll just produce that. And I had the benefit of working with the coordinator.
Showing this judgment.
Please, my lord. He was our secretary, my lord, Justice Anup Mendreta.
What did we hold?
Lord, your lordship has held the charge memorandum could not be quashed in the judicial review is what has been relying upon B.V. Gopinath.
If I get my gratuity, my lord, I will participate in the inquiry. I will not. My learned friend's apprehension. If I get my gratuity, I will participate in the inquiry, my lord. It's not that as if now they cannot punish me twice. It's like having the cake and eat it too. They want to throw me out and they also want to withhold my gratuity. Like my lord rightly observed, no loss is caused to them from me, number one. Second one, no charge sheet or even cognizance taken. Number three, 1802 clearly says there is no scope for withholding any benefit. It is not in the nature of penalty is what the rule says. Then withholding gratuity tantamounts to penalty indirectly. On all these three counts, my lord, they are not justified in withholding my gratuity.
In that event, Lord, may I come back on that, my lord, with this, judgments, Lord, if any.
You will find so many.
Lord, there are judgments in favor of the petitioner also. Since there's no pecuniary loss caused to the department, my lord, there are many judgments in favor of them, but
It is not such a case.
this is not such a case.
But upon a police report on such facts, upon receiving a complaint of facts which constitute such offense, how would you answer this? Upon receiving a complaint of fact which constitutes such offense, so the employer has made the complaint or was it a trap case?
No employer has not made a complaint. They say they learned from reliable source that it is likely to happen. It is not a case of, they have made complaint. The person whom they allege have given me bribe, they have made him also an accused, my lord. It is not the person who have given me a bribe allegedly is the complainant. Their very case is without any basis there. It is only an intention to sack my career, my lord. That is.
No, what do we get by doing it, sir?
Allah, there is no complainant at all.
It's not that. If your lordship may kindly turn to page 71, annexure A2.
No complaint.
Okay, which is the next case?
Next case is, my lord, on the very same charge, they want to initiate inquiry, they issued a charge memo, my lord. On the very same charge of FIR of which charge sheet is filed. Therefore, they say, we want to initiate inquiry. Having retired me compulsorily, my lien as a,
Why did you retire him?
There's a complaint of.
On
if you
the
lot-
same subject matter?
yes, sir.
if you lot- it's page 71 is the FIR. Based on this, my lord, he was made a compulsory retirement. Your lordship would get that at,
And that
If you take two actions,
double jeopardy.
how can you take two actions? Same subject matter, compulsory retirement. The compulsory retirement refers to the same charges?
Yes, my lord, exactly. And third punishment is withholding gratuity.
So you could not have taken subject matter, same compulsory retirement on this basis. So he's a deadwood because of that.
Please, my lord.
page 268.
And this offense relates to when?
This offense relates to, my lord.
2018, my lord. 2018.
No, it's not
You charge sheet today.
2018.
Have you issued charge sheet today?
No.
Huh? Then you can't issue Mr. 4 years limitation.
I'm sorry, my
My
lord.
lord,
Charge
charge
sheet is
memo,
issued.
charge memo is issued, my lord.
Charge memo is issued.
They issue.
Exactly on the last day of completion of 4th year, my lord. They have
It's there.
waited cleverly, and this is only targeting me, my lord. I don't know. I have in fact generated revenue to the tune of 125 crores to them, my lord. They have awarded me the best servant. Suddenly they turn back and all hell break loose on me.
22, before 4 years.
Couple of days, just 2 days before. And that too, they serve it through email, my lord. They do not even send it to RPAD.
It doesn't mind. Before
It
4
doesn't
years.
matter.
It doesn't matter. It's before 4 years.
Yes, when they can do anything.
Lord, may I come back on this, my lord, with some judgments?
My lords, if my learned friend is would appreciate and is agreeable to this proposition, my lord, I would like to submit subject to my lords.
Lord, your lordship could have it on 18th.
Please there, Mr. Bhushan, burn your midnight oil. Come to-
It's not that, my lord.
My lord, in that case,
I'll have to
just
get-
to help my
Because
friend, my
this is from Bilaspur. I'll have to, therefore.
just in case, let my friend also deliberate on this. I'll make only one request, my lord. If they want me to face inquiry, my lord, let them reinstate me back. I will face the ordeal of inquiry. Or if they want me to not go through inquiry, let them give my gratuity. At least that could be done, my lord.
We have to understand two things. One, once you have compulsory retirement, then you can initiate on the civil grounds. Two, is the cognizance.
Insofar as if he's compulsory retired, I don't think it's happening. That we should, my lord. This is what falls from the, this is falls from. The fact is that I can't say that because I've already filed a written statement before the tribunal and I've stated. Now here I can't say that.
What have you stated?
Not mechanically,
Page 189, my lords. They are fairly considered that cognizance was taken after almost 3 years. They are fairly considered to that fact.
from
189.
189. I read only about 185. 185. The rest is the 189, what we learned from the thing is the parallel from. All that I stated is this, my lord, it is submitted that in the meanwhile, the respondents have taken the decision to retire the applicant prematurely under Rule 1082A of the IREC in a public interest as per Annexure A1, dated 12/2019, and is being granted with the provisional petition as per Annexure A7. Because of the reasons that criminal proceedings are pending against it, it is also submitted the respondents have also taken a decision to initiate regular departmental inquiry against the applicant, and after obtaining sanction from the president, a charge sheet dated 22/4/2022 was issued to the applicant. Since applicant avoided to receive the charge sheet, a copy of the charge sheet pasted on the door of the residence on 26/4/2022. That was his last known address furnished by the applicant. A copy of the charge sheet dated so and so is filed as annexed. It is submitted the decision of the respondent in granting the applicant only provisional pension and to withhold the gratuity is in accordance with the rules and valid. It is clear from the reading of Rule 10 of the Railway Servants Pension Rules 1993, which reads as follows, that no gratuity shall be paid to the railway servants until the conclusion of the departmental or judicial proceeding and issue a final order thereon, provided that where departmental proceedings have been instituted in Council of Railway Servant Discipline and Appeal Rules 1968 for imposing any of the penalties specified in clause so and so of Rule 6 of the schedule, the payment of gratuity shall be authorized to be paid to the railway servant. A copy of the relevant extract as per Mr. Sami says, the applicant in fact receiving the full pension, enhanced family pension of ₹96,000, fairness of admissible from time to time, and he has received an amount of 1,03,10,000 towards the terminal benefits, except gratuity and committed value of pension. What it says is this, my lord, 10(3) is what? Rule 10 is what they say also.
But tell us one thing.
I'm sorry. There's one more.
Is he under suspension?
No, my lord.
You were neither under suspension. How are you paying for provisional pension? Because the FIR was before while he was in service.
That's the only ground for.
Where is this?
The para number 4.6 of my objections before the tribunal is this, but
Not on the exact point, my
one. Your Honor, could kindly turn to page 189. Para 4.6. Stand taken there in the averment of.
We did not suspend him also.
I just, the reason why the cognizance taken, the averment of the applicant in para are denied. In fact, charge sheet in RC number so and so was filed on 29/6/2019 and the Honorable Court has taken judicial note of it. In other words, the competent legal court accepted the same for taking cognizance and the cognizance was recorded on 10/6/2020.
What do you mean by this, that taken cognizance? We want to know the relevance of 10/6/22.
10/6/22 was the date of.
What happened on that day?
The document may kindly turn to page 209 onwards. 10/6/92.
page 212, my lord. Page 212. Objections were complied with and the charge sheet was taken on record. Yes. 213 onwards charge sheet. Lord, in fact, Honorable Supreme Court has Even otherwise, my lord, the law laid down by the Honorable Apex Court in Kandaswamy's case, in case of.
Only one judgment we require, Mr. Shantibhushan will have it. When do you want? 6th of April. Both the matters, we'll have both the matters.
My lord,
6th of April.
But this judgment, Kandaswamy, they say compulsory retirement, they cannot withhold any benefit because that itself is a punishment.
Right, yeah. Just-
Please.
Yes, ma'am. 6th April. Oh, Sunday, that's the reason. 6th is Sunday. Just give any date.
7th April. 7th April.
My lord, meanwhile, the interim an arrangement undertaken may kindly be extended.
Is it a written order?
Yes, my lord, written order, my lord,
The interim order, if I need to continue.
In-
What's that?
in both the matters. Undertaking taken by my friend, given by my friend, that he will not allow departmental inquiry to proceed ahead. That,
When Mr. Shantibhushan states his statement made on 25/9/24. We continue till the next date of it.
grateful.
That means what is the?
My lord, same, since matter is connected, same interim order. Actually, interim order is in the second case, my lord. But since it is the connected, my main matter, interim order is reflected in both the cases.
But no, we have passed only one order. In one case only we have.
Yes, my lord, in the second matter. But since it is the main matter to which the other is connected, it is reflected in both.
Same. The same, whatever. The submission, the submission made by Mr. Shantibhushan on 25/9/2024 shall continue.
Grateful.
Yes, at the request of Mr. Shantibhushan.
Instead of request, but upon hearing, it would be better. The reason is otherwise I would start time.
Just say that, this couple, we have heard the counsel for the parties. For some time to enable Mr. Bhushan to take instruction.
Please.
Ready notify them. Then those statements.
33 and 34 adjourns, 35, Mohan, 55.
Prepare for response number 2.
Yes.
I prepare for the accommodation in this matter, my lords. Prepare for short accommodation in this matter, my side, yet to receive the records.
In which matter?
Still number 35, my lords.
35 and 36.
36.
Yes,
Please.
I am for the appellant.
Or do you, why this thing?
But I only have the appeal memo. I do not have the other records, so.
So. You say.
I can give the copies of the documents
Just
if
give me
it,
a copy.
if at all they have not received, I can give the copies.
Let a copy, let the paper books be given to the learned counsel for the respondent. Which respondent?
2, my lords.
if 36 ಕೊಡಿದ್ದೀರಾ ನೀವು?
2 ಕೇಸ್ ಏನು ಕೇಳು.
36 ಇತ್ತಾ?
ಎರಡು
56
ಎರಡು same
ಇನ್ನೊಂದು
ಅಂತ.
ಕೇಸಲ್ಲಿ ಇದ್ದೀರಾ? 35 ನಂಬರ್. ಸೇಮ್
Service is complete now?
Yes, sir.
My lords, in respect of seal number 36, my lords, I undertake to file wakalat for R2, my lords. Seal number 36, I undertake to file wakalat for R2 because the
You are,
Venkatesh Somareddy, my lords, in the seal number
use the mic, please.
Venkatesh Somareddy, my lords. I'm appearing for R2 in seal number 35. The same person is R2 in seal number 36 also. So I undertake to file wakalat for R2 in seal number 36.
R2 also.
Please, my lords, in the seal number 36.
This will be filed by the council for the respondent number 2 in the registry.
In the meanwhile, I'll serve the copy.
You are for R2.
Please, my lords, in seal number 35, I'm already on record for R2. My colleagues,
Here it's Ganapati.
my colleague. My colleague.
Yes, sir.
So that,
I will give, I will, I have.
Let a copy of the appeal paper book be given to the council for
Yes.
R2.
Please.
Okay,
19.6.
similarly, just make a comment,
Yes.
then let wakalat be filed by the council for respondent number 2 in the registry. Okay. We'll do the date.
19.6.
Please.
Summons, Shri Anand Kher.
Kasturi. Direct counsel.
My lord, I'm
Yes.
appearing for the counsel for the appellant.
Yes, Mr. Kasturi.
My lord, this matter seems to be covered by your lordship judgment. Recently rendered.
Yes.
Relating to contract labor. In the sense, my lord, the labor courts holds the contractor workmen to be the employees of the principal employers. Then, my lord, the High Court, honorable single judge, confirms the order on a framing a wrong question. My lord, my submission to your lordship would be, if your lordship take up this matter, my lord, kindly page number 324, the order of reference. The points of dispute referred are whether the management of Leotek, so-and-so road, Rajajinagar, Bangalore, proved that the applicants Vijay Kumar and four others, Karnataka Workers Union, Gopal Building, etc., are the workmen of Madhu Enterprises, West Park Road, between 15th, etc. I am supposed to prove that they are the workmen of the contractor. That is the issue framed by the government. But the contractor is not made a party. Though the contractor comes on record, he files a statement that is rejected, but his evidence is taken. He has given evidence to the court. Lord, I have given a list of documents which you have filed in the labor court to show the workmen are covered by ESI, Provident Fund, and they are paid, salaries are being paid by the contractor. My lord, this matter, my lord, I have given a list of documents, exhibits.
Sir,
You will also will see number of
documents.
documents are filed with regard to wages paid, coverage by ESI, Provident Fund, etc. In fact, my lord, the statement filed before the labor court, Madhu Enterprises has given details of the payment of the Provident Fund number, code number, etc. Statement, page number.
Yes.
Yes.
133.
133 below. This is the evidence given by Mahadev Gowda, the contractor. I am a partner of Madhu Enterprises. The contractor, second party, Mr. Leo taken unit and set capacity. I am swearing to the affidavit. I am fully aware of the facts of the case.
I submit the contents of counter statement filed by Mrs. Madhu Enterprises contractor may be read as part of also. I submit Mr. Madhu Enterprises, which I am partner, has his office in so-and-so road, and the partnership document number 1. The office premises is document number 2. Karnataka Shops and Establishments Act registration is document number 3. And below, as contractor, I have also registered my establishment under the provisions of the Employees Provident Fund as Miscellaneous Provisions Act. Letter allotting employer code number is so-and-so. See also the letter allotting code number so-and-so of the Employee State Insurance Corporation. The action to carrying the second party work in the second party Leotech unit, the service of our firm were also engaged by Spice Telecom, etc. Copy of license is also enclosed. Our firm entered into agreement with second party Leotech unit. Separate agreement was executed by our firm Mrs. Unit. Madhu Enterprise Public Study Convenience maintain one common attendance register and wage register in respect of unit number 1 and unit number 2 of Leotech. The provisions of the Contract Labor Act and Shops Act does not call for maintenance of separate registers in respect of each unit. In support of the separate, I am producing the following documents. Today, document number 1, the contract, then agreement executed, register of wages, then muster roll, ESI, Provident Fund, etc. All this. Then below, what has happened in this case is, where the register documents and muster rolls are not seen by the court. The court seems to take a view, the evidence given by the management, kindly see page 226, Lord. Para 24 of the award. Para 24 of the award. An attempt has been made by the second party, placed in reliance on the attendance register and also wage register. As already stated above, the work done by all the first party workmen and the second party management is permanent in nature. And the very document maintained by Madhu Enterprises are nothing but to the benefit of second party management by adopting unfair labor practice. You know, the question is whether they are the employees of Madhu Enterprises or not. The court doesn't decide that. You are permanently working more than 240 days. The way is that all the evidence given is only to support the principal employer. Therefore, I reject it. This is approach. Kindly see, my lord, the actually the statement filed by the Madhu Enterprises, who is not.
But have you, Mr. Kasturi, have you complied with 17B?
No, I'm sorry, I have not.
But that need to be complied with first before we hear you.
My lord, I'm a very poor employer. I am also not very.
4 units.
Of course, they become poorer by engaging me. That's a different matter.
You say the employer is poor. He will say, the learned friend will say, we are the poorest.
4 units. They are running 4 units, my lord. 4 units.
So what? They are running out of losses. My lord, my submission is, my lord, I will immediately pay 50,000 rupees, my lord, to this people. Hear this matter. It won't take more than 10 minutes for your lordship to dispose of this matter. Squarely covered by your lordship judgment.
First 17B need to be complied with, Mr. Kasturi. That's the law.
Make it. I filed an application for modification, my lord.
Modification on what ground?
Ground is, my lord, I am also living with hand to mouth. I am not able to.
That's no ground, Mr. Kasturi. You know what is the.
I know that, my lord, your lordship, kindly bear with me. But the only thing is, I will pay them 50,000 now. Immediately, your lordship will dismiss me. Hear me for 10, 15 minutes.
How much are the areas? How much are the areas?
3 lakhs each it comes to.
How much are the areas?
2 lakhs each.
Pardon?
2 lakhs each, my lord.
Oh, okay. How many employees are there?
4 employees are there. Out
4
of that,
employees.
only 3 are claiming 17B because one of them is partly working as a security guard. So he has not applied for it. 3 of them have filed affidavits complying with the saying that I'm not in employment. I'm ready to join work if they give me work. And I had the benefit of 17B throughout that they had not challenged before the lower court. Before this court, and they fell in, they didn't pay almost around 2 lakhs before the lower court saying that we will comply with 17B only from the date when the stay is granted. and not from the date from which it is award was passed, they said, and till the end, they did not pay, my lord. And before this court, my lord, almost a year now, they are just dragging on the proceedings, my lord. They have filed an application for modification of the order, my lord. That's it.
Yes, Mr. Kasturi.
My lord, we have even asked for a summoning of records where they are employed to get the PF documents. I am not able to get it. But the only
There's an
thing,
order. There's
I will
order
pay
passed
immediately
already.
50,000 each. Your lordship may hear this matter, my lord.
Whatever you, no. Hearing is only after that compliance is there, Mr.
I know, my lord. Have some sympathy, my lord.
You're right. We have to see both the parties.
Yes, your lordship is right. My lord,
So
At
I
least,
think that's
Lord.
what the law is only. You know better. We have to learn
my
from
lord,
you.
my
Mr.
lord, law is like this. Our division bench has said, when the employer's jurisdiction of the court is questioned, you cannot grant 17B.
No, that we will look into it on merits. Surely we will look into on merits. But today,
Not
right
on
here,
merit, 17B.
Very well.
17B.
What is the challenge on 17B?
Challenge that they say, my lord, if the court is convinced that the lower court has passed an award and had no jurisdiction to do so.
No, Mr. Kasturi. That there is an award against you in their favor. The conditions precedent for 17B are fulfilled. There is a case, there is a direction for reinstatement. The 17B must follow.
Lord, make it at least some money I'll pay, my lord, kindly.
Whatever you feel like. But we want that compliance of 17B be made.
Lord, I
That
will
needs to be
pay
done
some money
first.
to them now. And your lordship may kindly hear the matter just before. It is covered by your lordship judgment. 2 minutes it will not take for two.
We are with you on that. You comply 17B, the same day we will pass, we will hear you finally. We will hear you finally. See, when the Supreme Court says, without
Yes,
hearing
your lordship knows.
17B, you
I know
can't
this
go.
procedure. I can't say anything about that.
So that you tell us, we will have it the same day. Whenever you want, we will hear you. We are ready to hear you.
No, 17 becomes to 2 lakhs each, my lord.
Whatever be, whatever, we are not on the figure. Maybe it is 1,000 or maybe anything else. We are not on the figure. We are on a principle of compliance. That's all.
Lord, if I
Yes. So when do you want?
but I want now, my lord. I will convince your lordships.
No.
10 minutes it won't take your lordship to
No,
do this.
Mr. Kasturi, no. First 17B need to be complied.
My lord, 50%, my lord, I'll pay, my lord.
No,
1
we
lakh
say
each.
nothing. We say nothing. We want compliance of 17B. In whatever manner you want to pay, you will pay.
I'll do that. Your lordship will give me 1 week's time, my lord.
Surely,
I
we will
will,
have it after 1 week.
Very well.
Yeah, just say that at the request of Mr. Kasturi, learned senior counsel
He's
for
got
the
an
appellant.
principle.
Re-notify. Just give it next week.
17.3.
Thank you.
Much obliged, my lord.
Next.
Number 26.
My lords, I appear for the appellant, my lords, since number 26. My lords, this is a matter, my lords, where our grievance as KPCL is that without our consent, my lords, the BBMP has extended. My lords have directed the BBMP, my lords, to come back and tell my lords as to whether he is still in service and whether they intend to continue him.
Yes.
My lords, I am given to understand, my lords, subject to correction by my learned friend for the BBMP, that while he was in BBMP, my lords, I believe that the Lokayukta has initiated some kind of an action against him for corruption, my lords, something relating to that, subject to correction by my learned friend. And he's still continuing in the BBMP, my lords. And BBMP has again unilaterally extended it, despite our letters requesting him to send him back, my lords.
But what is this is between both of you? You appear for
I
whom?
appear for BBMP.
Now, what is your case? He will continue to with you. Huh?
Continuing with the solid water waste management department, my lord.
But how long you can he be? He is there. The lane is there.
But they have extended, my lord. The state government, my lord, should take a call if they extended or not.
We don't know.
State
See,
government
there
has-
has to be. The difficulty is either they should say we are not extending.
We have said so.
You say
We
you
have-
are not extending. What is this? The gentleman is continuing. If he is required in the space, he is also required there. That's right. He ultimately working for the public.
Yes.
Either way, then there has to be. And how far? How long? It can't be time immemorial infinity that he will continue. And the rules are very clear. Deputation is for how many years?
2 years.
You don't know. I don't know about how this is happening. So you tell us. What?
I will put it on affidavit, my lord, if BBMP needs services or not. Otherwise, till when it is being extended, I'll put it on affidavit, my lord.
Notice issue.
Yes, my
All
lord.
parties are working. Just say at the request of counsel for the BBMP to file an affidavit. To file an affidavit, re-notify after how much time?
Weeks time, my lord.
Weeks time. Just have it after 2 weeks. Rejoinder be filed within 1 week thereafter by the appellant. Karnataka Power Corporation Limited. Okay, have it after 2 years, 3 weeks.
3rd April.
Affidavit. BBM.
Grateful.
How many years he has put in? When did he come?
But he is joined.
My lords, from
Years.
2008 years, my lord, 2017 onwards, my lords, he's continuing that organization. And my lords, he's doing such an excellent job that BBMP has initiated disciplinary proceedings against him also, before corruption, that too.
What is his expertise?
But he's an executive engineer, my lord, assistant executive engineer.
So they require here also come.
Same kind of corruption agreed with there. Obviously.
Okay, thank you.
Obligement.
Why does he need such kind of a